Good morning, everybody. Happy Super Friday, the last one of the year for us. Welcome to the Courtroom Files Live. Those who conspire against us were attempting to stop our final trek through Super Friday today. I tried to go live and nothing was working, but I got it going. We're holding it together with chicken wire and duct tape, but doggone it, we're going to have a good day. And we're going to start out with Mindy Glazer because we haven't been there in a minute, so let's see what's going on in Miami-Dade.
You were arrested for grand theft of a vehicle. It's charged as a first-degree felony and petty theft.
Muy bien, buenos días, señor. Usted está siendo acusado de hurto en mayor cuantía vehicular y además de hurto en menor cuantía. Esto consta el de hurto mayor vehicular como un delito mayor en primer grado.
I will appoint the public defender's office for you.
Le asigno el abogado de oficio para que le represente.
There's no value for the vehicle.
Right, it may be an F1, but there's nothing listed.
No tenemos aquí un valor enumerado en cuanto al vehículo, indica la fiscalía. Quizás sería un delito mayor en primer grado, pero no hay nada enumerado.
You want me to reset it for probable cause hearing?
¿Quieren que lo aplace para motivo fundado?
Look at his priors.
Mire sus antecedentes.
We can reset it.
I'm going to
Podemos
reset this for
aplazarlo.
probable cause hearing in the afternoon to find out the value of the stolen Mercedes that he was driving.
Vamos a aplazar esta causa hasta el calendario de la tarde para una audiencia en cuanto a motivo fundado para determinar el valor del Mercedes que presuntamente se ha robado.
See you later.
Le veo más tarde, señor.
Next on page 3, Saul Acuna Morgan.
He has a hold for immigration.
Okay. Good
Spanish.
morning. Sir, you were arrested for possession of a controlled substance called methamphetamine, possession of drug paraphernalia, trespass on property, and prohibited camping on Miami Beach.
Buenos días, señor. Usted fue arrestado y enfrenta acusaciones de haber estado en tenencia de una sustancia regulada llamada metanfetaminas, además de haber estado en tenencia de adminículos para consumir drogas, además de haber entrado sin permiso a una propiedad y además de haber estado acampando en una zona de Miami Beach.
And you also have an immigration hold.
Y además tiene una retención por parte de las autoridades
I will appoint
migratorias.
the public defender's office for you.
Le asigno el abogado de oficio para que les represente.
There's probable cause for the charges. Count
Tenemos
one,
motivo fundado en estas acusaciones.
possession of a controlled substance will be $1,500. Count 2, possession of drug paraphernalia is $500. Count 3 trespass on the COs is $500. And count 4 prohibited camping is $150.
En cuanto a la acusación número 1, el haber estado en tenencia de la sustancia regulada, van a ser $1,500 de fianza. La acusación número 2, los adminículos para consumir drogas, van a ser $500 de fianza. La acusación
Have a
número
nice
3,
day.
el haber entrado sin permiso, $500 de fianza. Y la acusación número 4, el haber estado acampando en una zona en la que no podía, $150. Tenga buen día.
Right, next we have Shady McLader
He has a hold for immigration.
Frias. Okay,
He has a hold for immigration.
thank you. Page 3.
Spanish, please.
Good afternoon, sir. Good morning, sir. You were arrested for 2 cases. They are false imprisonment and battery, robbery by sudden snatching, and domestic battery by strangulation.
Buenos días, señor. Usted está enfrentando 2 casos con acusaciones de haber privado de la libertad a una persona ilícitamente, de agresión física, de estrangulamiento y además robo por haberle arrebatado el artículo a la persona.
Right, Public Defender's Office is appointed for you.
Se le asigna el abogado de oficio para que le represente.
There may be somebody here for him.
The
Quizás
bondsman,
haya alguien
maybe?
presente aquí en su casa.
I think the alleged victim's here.
Okay.
Parece que la presunta víctima está presente, indica la defensa.
I'm sorry, that's his sister. My
Perdón,
apologies.
es la hermana.
It's his
Me disculpo.
sister.
Right.
So there's probable cause for the charges on F-25-27125.
Tenemos motivo fundado para las acusaciones en el caso F-25-27125.
And that's the case from October. I'm reading the other case now.
Ese es el caso que data en octubre. Voy a leer ahora el otro caso.
There's probable cause on the other case as well.
También tenemos motivo fundado en el otro caso.
Sir, you are ordered to stay away from the alleged victim whose initials are SQ or Sophia Quintero.
Señor, se le ordena estar alejado de la víctima en el caso cuyas iniciales son SQ o Sofía Quintero.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No se le permite tener contacto con la víctima de forma directa, ni indirecta, ni en persona, ni por escrito, ni por teléfono, ni a través de terceros.
No contact with the victim through social media or other electronic means.
No puede contactar a la víctima a través de los medios sociales ni ningún otro dispositivo electrónico.
And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Y tiene que estar a todo momento como mínimo 500 pies alejados de la víctima, el hogar de la víctima, escuela a la que asista o centro de trabajo.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
Usted no puede involucrarse en ninguna actividad delictiva y tampoco puede usar o consumir ningún tipo de droga ilícita.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Usted no puede utilizar, comprar, portar o estar en tenencia de ningún tipo de arma, arma de fuego o municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons, permits, to the nearest police department and file a receipt with the court.
Usted tiene que inmediatamente ir a entregar al precinto policial más cercano que le quede cualquier tipo de arma de fuego o permiso para portar armas ocultas que usted tenga y el recibo que le den presentarlo ante el tribunal.
And you may return to the victim's residence one time only within 48 hours of your release from jail.
Y usted va a poder regresar al hogar de la víctima solamente una vez en un plazo de 48 horas, acompañado de la policía.
You must be accompanied by a police officer
Recuerde que tiene que ir acompañado de un policía
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork and work tools,
para que usted pueda recoger sus pertenencias que necesite, dígase su ropa, sus herramientas de trabajo, sus medicinas, documentos importantes.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Sepa, señor, que si usted regresa al hogar de la víctima o si usted permanece ahí sin estar acompañado de un policía, será arrestado nuevamente.
Do you understand the stay away order, sir?
¿Entiende la orden de alejamiento, señor?
Comprendo.
I understand.
Thank you. I'm setting a bond in F25-27138. Count 1 is $2,500 and count 2 is $5,000.
Voy a establecer fianza en el caso F252713. La primera acusación, primer cargo va a ser $2,500. El segundo cargo va a ser $5,000.
On the other case ending in 25, count 1, false imprisonment is $2,500. For the bond in count 2, battery is $1,000.
En el otro caso que termina en 25, voy a establecer en cuanto a la primera acusación, la privación de libertad ilícita, $2,500 y la agresión física, $1,000.
Have a nice day.
Tenga buen día, señor.
And Madam Interpreter, can you also let Mr. McNally know that our office does not recommend posting his bond at this time? He should speak privately with his lawyer regarding his situation.
Señor, sepa que la abogada defensora le indica que su bufete no le recomienda pagar la fianza en estos momentos, que les recomienda primero conversar con su abogado.
Okay.
Ok.
Next we have is Craig Pearson. Good morning, sir. You were arrested for grand theft of a vehicle. It's charged as a second-degree felony, resisting an officer without violence, criminal mischief, petty theft. I will appoint the public defender's office for you. You're also on probation. There's a hold for you to see the judge on Monday for your open felony case, 2 open felonies. F22-13324 and F21-18471. The public defender's office is appointed. I'm reviewing for probable cause.
Judge, I'm going to review regarding the hold.
What?
I'm going to review, see just for the whole, regarding the hold.
Oh,
I think maybe he's not. I'll check it out too, then, Ms. Corey.
So there's, I don't know about, there's no value for the grand theft.
No.
I see that he took a probation plea.
What?
Looks like he took a plea to the violation of probation, judge, and did jail time. It should be closed out. It was supposed to terminate upon completion of his jail sentence, is what I see.
And then I
Huh.
checked the DOC website. It doesn't show him out on probation.
It says he's still on probation.
It says he is not.
He's not on
See,
probation.
I think the clerk needs to close the file. Looks like it's still set for report for June of 2025. I don't think it was ever closed out.
Okay, so there's no hold for those two probation cases. Probation's closed. Count one, I don't see a value. You want me to reset it?
No, third degree's fine.
Count one, there's probable cause for grand theft of a vehicle, $2,500 bonds. Count two, there's probable cause for resisting an officer without violence, $500 bonds. Count three, petty theft.
Count three's criminal mischief.
Oh, I'm sorry, I'm looking at the wrong. Am I looking at- Count three is criminal mischief, pardon me. That's probable cause for that. It's a second degree misdemeanor, $500 bond.
Is
Count
it
four,
a, okay.
the petty theft is a stolen tag. $150. Have a nice day.
Good morning once again, everybody. Happy Super Friday. Welcome to the Courtroom Files Live, where apparently the chat is in Latin this morning, so that's very cool. Let's change it up a little bit. Let's go to Michigan. We'll say good morning to Judge Elmore and to Ellie. Hi, Ellie.
All right. Here on the record today for the 28th Circuit Court here in Wexford County, and we're going to take up next the case of the people of the state of Michigan versus Stacy Edward Welch Jr. This is file number 25-14158FH. Appearances, please.
Nate Carnes on behalf of the people. Robert Hartzell for Mr. Welch, who joins me at the table, Your Honor.
Thank you. That's all right. You may be seated. Thank you. Okay. We are here today for an initial pretrial conference in this case, and we held that in chambers, myself and counsel, a few minutes ago. And the counsel informed me that they had reached a pretrial agreement in this case, and therefore we're here to enter a plea. Mr. Carnes?
Your Honor, it's my understanding that the defendant will plead guilty to count one, which is controlled substance delivery or manufacture of methamphetamine, MCL 333.7401 2BI.
Okay.
And the people will dismiss count two, which is the exact same charge. It's also my understanding that the defendant has agreed to pay restitution based on the conduct alleged in both counts, and that restitution total is on the sheet that we turned in. Migrated out of my file.
Well, let's see if it migrated into my hands.
I had
Looks
it,
like I've got
$1,750 to the Travers Narcotics Team South Office.
it. That was allegedly by money.
Yes, Your Honor, by money.
Thank you. Mr. Carnes, is that a
Gonna interrupt. Lindsay, $50 super chat. Thank you so much. That's incredibly generous of you. And again, I appreciate all the support you've given me over the last year. It means a lot. So thank you so much.
delivery, but it's actually a delivery?
Yes, my mistake, Your Honor.
That's okay. Thank you. All right, Mr. Welch, is that how you wish to handle this file?
Yes, Your Honor.
All right, please raise your right hand. You may remain seated. You swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. All right, Mr. Welch, you are currently charged with felony information with 2 counts. Each count is a charge of delivery of the controlled substance methamphetamine. Each one of those are a felony, punishable by up to 20 years and or up to $25,000. I'm told that you're going to plead to one of them and the second one will be dismissed. If you enter a plea of guilty, you'll not have a trial of any kind. Does that make sense?
Yes, Your Honor.
By entering a plea of guilty, if I accept that plea, you'll be waiving certain rights. I'm holding up a piece of paper that at the bottom has your signature. At the top, it says advice of rights. Is that your signature?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
And did you understand what you read?
Yes, sir.
All right. Additionally, if the plea is accepted, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to the court today on the record. Other than the agreement that Mr. Carnes and Mr. Hartel have told me about, have there been any other promises, threats, or inducements or force to get you to plead guilty?
Yes, Your Honor.
Are you therefore entering the plea of your own free choice?
Yes, Your Honor.
Okay. Now, when there is a conviction for a felony in a state court here in Michigan, there's what's called the Michigan Sentencing Guidelines that help the court determine what is a fair, reasonable, and proportionate sentence. I suspect Mr. Hartel has talked to you about those and tried to give you an idea or estimate as to what they would, how you would score and what the range would be. Is that correct?
Yes, Your Honor.
He's probably also talked to you about what he thinks might happen, just based upon his experience, not only in other courtrooms, but even more particularly here in this courtroom in front of me. Has he done that?
Yes, sir.
I want to highlight for you that whatever he's told you about the guidelines is just an estimate. That has to be prepared by the initial scoring is done by the Department of Corrections, and we'll talk about that in a little bit. But it's just an estimate. It's not a guarantee, because what's going to happen is when we come back to court for sentencing, if I accept the plea, we'll have those guidelines, and each side has the right to challenge them. So somebody might, Mr. Carnes might think, well, the court guidelines should be higher. Mr. Hartel might say, well, they should be lower, but I'll make the decision. The key point is that no matter what those guidelines are, they are not mandatory. The court is allowed to go above them or even go below them. I just need to make sure you know that. So anything that he's told you is merely an estimate, as it is the judge alone that determines the sentence. Do you understand?
Yes, Your Honor.
Do you have any questions about what's going on today?
No, Your Honor.
Okay. So with knowing all that, do you still wish to enter the plea today that we talked about?
Yes, Your Honor.
As to count one, the delivery of methamphetamine, this one deals with the alleged date of October 16th of this year. How do you plead? Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. So turning your attention to, and while I know on the felony information here, there's a date range, but I can see that those date range, or that date range is really just based upon the two dates as alleged. On October 16th of 2025, out in Herring Township, which is on the north end of Cadillac here in Wexford County, what happened?
I sold methamphetamine to another person, Your Honor.
Okay, how did you make, how were the arrangements made for you to meet that other person?
They called and have me come down and meet them.
Okay,
And I agreed to it.
and where did you meet? Okay, so in the Home Depot parking lot?
Yes, Your Honor.
Okay, and when you met with that other person, where it was outside, is that correct?
Yes, Your Honor.
And when you met with that other person, did you deliver some amount of methamphetamine to that person?
Yes, Your Honor.
And while money isn't required for a delivery, did that person deliver you money in exchange?
Yes, Your Honor.
And then you left the area, is that correct?
Yes, Your Honor.
Now, you said you came down, where'd you come from?
Saginaw.
All right, thank you. Do you remember how much that you delivered and for what it weighed or how much the amount was?
I believe so. It was around like 50 or 47 grams, I believe, Your Honor.
Okay, and then you received money for that. All right, thank you. Mr. Carnes, do you believe the defense provided a factual basis?
Yes, Your Honor.
Mr. Hartel, do you agree?
I do, Your Honor.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Hartel.
Or mine.
Mr. Carnes, you believe the court is in compliance with Michigan Rule 6.302?
Yes, Your Honor.
And Mr. Hartel.
Yes, Your Honor.
Thank you. There's one more term I just forgot that I need to go back and review before I accept the plea. You understand that there's an agreement that you were going to pay back an amount of restitution to the Travelers Narcotics team, which is probably the one who conducted the sting. And that is a certain amount, and that amount of money is $1,750. Do you understand? And you agreed with that? And so it must have been over the 2 instances you collected that amount of money. Is that right? All right. Well, the court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense for count 1. Therefore, the defendant is found guilty of count 1. Count 2 will be dismissed at the time of sentencing. Sentencing will be done in about 4, maybe 5 weeks because of the holidays. We do sentencings every Monday morning in this courtroom. Whenever someone is convicted of a felony in a state court in Michigan, the Michigan Department of Corrections must prepare what's called a pre-sentence investigation report. That report is prepared and given to the court just prior to sentencing. The court uses it to help establish a sentence. That report will include a description of the offenses, the pretrial agreement, statements or information you make or provide while it's being prepared. It will also make a recommendation as to the sentence. It's strictly a recommendation, as they don't work for me and I don't work for them, so I determine the sentence. It will also include a scoring of the guidelines, and the guidelines, as I mentioned with you earlier, are not mandatory. It will also talk about any prior criminal history you have or don't have, how you performed on probation or bond in the past and this time. Anyways, there are 3 steps that involve you for the preparation of this report between now and coming back here for sentencing. First, when you leave the courtroom, you're going to go downstairs to their office. If you take the elevator all the way down, step out, do a button hook to the right, you'll go down a slight ramp. There's a door straight ahead. Go through the door. Their offices are in that hallway. Because I think I've been told you're on a tether. If you've gone to the community corrections office, if you were standing right in front of the office and did an about face, you'd be facing their office. Now they're going to give you a packet of information that's going to ask a lot of questions, and you're going to fill it out and turn it back in. Second, they'll have an interview with you, and you have the right to have your counsel present during that interview. And number 3, Mr. Hartel will get that report generally about 10 days, maybe 2 weeks before sentencing, and he's going to have to go over it with you, because each side has the right to come back to this court and request corrections or make objections to the contents or the scoring or whatever. So we need to make sure that it's complete and accurate before the court uses it to give a sentence. So that also means you need to maintain your communication and contact with Mr. Hartel, as he will also need to let you know when you need to get back to court next. All right. Any objection to Mr. Carnes to the continuation of bond?
No, Your Honor.
Your bond hereby continues. I know Mr. Hartel is going to make a motion, but I have to make that finding before he makes his motion next. So we're moving right along. Mr. Hartel, go right ahead, sir.
Thank you, Your Honor. I would ask the court to consider removing the GPS tether as a bond condition for what it is worth. My client is working with his father. They do Speedy X, if I understand correctly. It's a subcontractor for Amazon.
For FedEx, like it's just a third party Amazon. So
Yeah, I understand.
So he does have family support as well. Supervision might be a stretch of the term, but he does have family supporting him. Family who is in the courtroom for support, his father and other family members. I would ask the court to give him that opportunity. The GPS does cost him quite a bit. I mean, that is one of the benefits of being on bond, obviously, but he is low income. I have done that type of work myself. A lot of the air quotes income goes back into resources to keep being able to do the job. So it would help him out quite a bit. Plus, if there's unexpected stops, community corrections, rightfully so, always wants to know what's going on, but sometimes you just need that extra bit of gas or whatever the case may be. So I would ask the court to consider that. I don't believe we've had any concerns with him on bond thus far. I don't think we would moving forward. I had quite a heart-to-heart, not only with him, but again, also with his family. And I do believe his family would, not that he would ever go off the tracks, but if he started to, they would put him right back on. I'll phrase it that way. I'm paraphrasing the pics. I don't want to say exactly what his dad said.
I got it. I have kids, so I know what I'd say to my kids, so.
Basically, yes.
All right, Mr. Carnes.
Thank you, Your Honor. I did look through the file. I don't see any bond violations. And I do recall we did a stipulation to allow him to travel to a different family member's house for Thanksgiving. There were no issues there. On the other hand, these are very serious charges, and I can understand the court wanting to keep all these conditions in place. He is also subject to random drug testing, which includes recreational marijuana. And again, we have no violations. I'll leave this completely up to you. Thank you.
Thank you. I love it when they say they'll leave it completely up to me. It is completely up to me. That's all right. All right. Mr. Welch, how old are you?
21.
Okay. There's someone out there, or more people, that were pulling your strings. And you fell victim, most likely, without me knowing exactly what's going on. And I don't mean to be guessing or stereotyping to be rude, but because you're young and you've got a family, right? Those are your children?
Sure. Well, that's my little brother, and then that's my youngest son.
Oh, okay. All right. All right. He's a cutie. All right. Odds are, because this happens on occasion up here, smaller towns in northern Michigan, and it's unfortunate, but I guarantee you, there's a group of people who are pulling the strings, and here's what they do. They don't come up and deliver because they're scared, and because they're not very bright, and because they use young people like you to do it because they think you're going to get 7411 HYTA status. They think that your likelihood of getting prison is pretty low, or jail is pretty low. We get the same young people that come out of Muskegon. They come up from Saginaw or Detroit. It's the same thing. Where are they helping you pay for your community corrections tether? It's okay. You're not going to answer the question. You know who they are. You're not going to answer and tell me who they are, their names. I got it. I'm not going to ask you that. You don't need to give it to me. But there's some people out there who are jerks who do not care about you and your family, because there's no way that you, most likely, made, from what I understand, 5 golf ball size amounts of meth. Right? You had about 5 ounces. All right. I used to sit over there when I did. The most I ever had as a prosecutor was about an ounce. Maybe, I think one case had about 1.5 ounces. It's now 3 times the amount. And it's because of these drug dealers that are using young people like you as scapegoats, because they do not care about you and your family. So when I think about this, I know you've got some financial obligations. You have family obligations. And don't blame the parents at all, right? Young people do stupid stuff. I'm sure Dad may have done something stupid once. I know I've done stupid things more than once. I'm sure Mr. Hartel has, and so has Mr. Carnes and everyone else in here. So I'm not trying to lecture you, but I'm sitting here and I'm wondering if there's a message that needs to be sent, so you can tell the other guys like you, because you and I know, without you even telling me, there you probably have friends or other people you know who are doing the same stupid stuff because of some group of idiots who are just drug dealers and only care about themselves. Because if they cared about you, your family, or anyone outside of themselves, you wouldn't be doing this. Or they would have done it. Who knows? They're cowards. So I also need to let you know your likelihood of getting a period of confinement is extremely high, right? I can tell that if you have no prior convictions, which I was told that you don't, at the very minimum, you're looking at a sentencing range of probably 12 to 20 months, which means I'd have to find substantial and compelling reasons to go below 12. And 12 would be in jail. That would get you 365 days with about 60 days of good conduct time. So right now, without knowing anything and without somebody arguing to me that I should give you and find substantial and compelling reasons to go below, your likelihood of going to jail for the 10 months is pretty high. I can tell you it's very high. I've never not sent somebody with a delivery charge to confinement. So I trust. So I know Mr. Hartel, and he's a good defense attorney. He's a good guy. He's very honest. He's probably told you that. So I'm going to tell you that I'm going to leave you on the tether, because underneath the court rules, I understand that the likelihood of conviction is obviously is done, and the likelihood of confinement is quite high. Because not only am I going to send the message to you, my likelihood is I need to send the message to all of those other friends of yours out there that you know that you were shaking your head about. They're going to get the message, don't. And I haven't made up my mind yet because I don't know anything about you. I'll say this. You look like a nice young man. You got a nice, some nice people back there. And I love that hat. By the way, I normally make everybody take their hats off, but that one can stay on. It's cute. It looks a little bit like an Ewok. I don't know if you know what Ewoks are because you're too young. Star Wars, never mind. I've just dated myself. So a lot of what I'm trying to say here is I don't know exactly what I'm going to do. How you do on bond is very, very, very important to me. So I'm going to leave you on the tether. I know it's expensive. We're going to see how you're doing. All right. How you do goes a long way with me on what I do for a sentence. You don't want, here's a tipping scale. 12 months is jail. With anything below 12 months is what I'm trying to say. So whether or not I give you 6 months or 12, or I put you on work release, or I do something else, that's jail where you get good conduct time. So at the most, it's 10 months. 1 day over, prison. Don't get good conduct time. Okay? Do you have a high school diploma?
Yes, sir.
Fantastic. That's a great bonus for me. And you're working hard. I want to make sure you keep working. That goes a long way with me too. When I see people who don't work, don't have a diploma, it's real bad for them. So I'm going to leave you on this because I want to see how well you're doing. I want to keep your nose clean. Okay. So I know I've talked about a lot of bad things and whatever. I'm not trying to be rude, but that's what you need to do. You need to go back. Dad, you might have some idea of who some of his friends are. Make sure they know these people are using them because they think he won't get any punishment. So that's what we're going to do. I'm going to leave you on it because you want me watching you. You want me seeing how well you do. That's really what's important. Plus, if I keep you on tether, odds are you aren't going to those people because they know I'm watching you. That's also another factor. All right. Thank you very much. We'll see you here in about a month. Don't forget to go downstairs to the Department of Corrections and start that PSI paperwork. And take care of the kids. a good Christmas, okay? Learn from this. That's all that this is about, learning, sending messages, stuff like that, okay? I want to make sure that you never, ever get used by a bunch of jerks again. Right? The people behind you are much more important than them. And you can tell them, I generally keep my stuff on YouTube. You guys are not helping young people. Good luck. We'll see you in about a month. Thank you. We're adjourned.
Okay, so Michael, 5 gifted memberships. Ashley, 20. Lindsay, who already threw down a $50 super chat, gives another 5 memberships. I just want to say thank you to all of you, not only for today, but for the whole year. It's no secret that the last 6-7 weeks or so have been a bit of a struggle here at the TCF bunker. But I keep coming back every day, and it's because of you guys. And it's not because I'm looking for you to throw money at me. I enjoy being here. And I can tell from the stats right now that there's probably a bunch of people out there who are new to this live show. Step up and say hi in the chat. This community is tremendous. Get to know these people. You'll come back for more. This is the best place to be in LawTube in the mornings. And I'm not just saying it because I'm running it. I'm saying it because of the quality of the people who come here. This is a great community. So thank you to all of you. You're keeping me going during very interesting times. Barbara, thank you for $10. Very much appreciate it. Again, you guys mean the world to me. So at the bottom of the next hour, we're going to talk a little bit about what's going to happen with the channel in 2026. Things are going to change a little bit. I think it'll be for the better. So in about an hour, we'll have some discussions. So be ready for that. But yeah, you guys are the best. And who is that? She's Maker. I popped in to say thank you to whoever gifted the membership to me. Well, that was either Lindsay or Michael or Ashley. And welcome. It's good to have you here. So yeah, let's go to Texas. Let's say good morning to Judge Stevens.
That's
We have
Monday.
an NPRP and a new case.
Right. We had a court hearing last Monday and she had car trouble and appeared here at about 10 o'clock instead of 9. I was gone, but she did show up. And you placed her into custody.
Yeah.
So
I think that was one of the reasons.
So I had an active warrant for her arrest.
Mm-hmm.
It wasn't because she was late. She also had another. It was good reasons for the NPRP.
Oh, yeah, for the FPRP. Yeah. And this case happened in June. And the MPRP wasn't filed until a couple of days before December 4th. In this case. But he had a court hearing on the 9th.
She wasn't indicted until September 10th.
Right.
And
the MPRP was filed, I think, December 4th. They're asking.
Yeah, well, that.
And the next court date was December 9th. She had a court date on the 9th. She knew about the warrant and she knew that she'd have to take care of it. So I filed prior to the 9th a motion for the court to consider a bond.
Okay.
So
Where you want to add?
well, this is the holiday season, Judge, and where
most thefts occur.
She was
I know you. How many thefts are too many? In your indictment, how many prior thefts are alleged in your indictment? This is your life. You know more than all of us about your life. Let's see if you can guess correctly. How many theft convictions are in this indictment? Previous that you've been convicted of? How many? Ma'am? 9. And then we've got the new indictment. And now the new motion to revoke probation. How many is enough, my goodness? Don't you think going to jail the first time would have said, oh, That's like sticking my hand on a burning stove. I'm not gonna do that. But you're not just sticking your hand on it, you're embracing the burning stove. Now you're embracing it. It's like it almost, this is what you do. What you enjoy doing, because you're doing a lot of it. And, but we, you know, we had for the first, at the very first one, we, some court, well, I mean, maybe my probably wasn't, it was probably a county court. They made a deal about it. It was important. They said, hey, look, you know, this, you're going to go to jail if it's. Now you're going to a prison. You can go to prison now because you've had something. When you steal a pack of gum, it's a felony. If you steal a pack of gum, it's a felony the rest of you. That's because you've gotten this. But no, I can't. As much as I'm the gift giver, but at this time of year, no, it's like me sending a DWI person out there. This is where people steal the most and where they drink the most. And unfortunately, you are paying for your actions. You're being held responsible. And the people who follow the law, most people, they don't feel sorry for you. I mean, maybe the first time, okay, you made a mistake. Everybody makes mistakes, but this is your 10th mistake. They're saying this is your 10th one. No, you're what you are. It's turned into your personality until you can prove that you're much better.
And you're putting out that alone.
No,
I have to tell you.
no, yeah, I'm sorry. No, you're
And I
you were
work on-
previous. No, let me speak.
Yes.
9 convictions. Your last one is in this court on November 21st of 2024. So how did you celebrate that? A few months later, you commit a new one, and it resulted in this indictment here. So this is your 10th one. After we made a big deal about it, and you went right out, and didn't take you long before you were stealing again. But no, we're not. We're going to resolve this before we're not. And there you are at Dillard's. Just stealing, trying to steal stuff at Dillard's, which is why the prices are so high at some places, because not Dillard's necessarily, but at some places prices are high because the honest people who purchase things have to pay for the losses that result in higher prices because of the people who steal. And that's why jurors on thefts, they don't find it amusing because they're victimized by the prices. Generally, they're not criminals who are in the juries. That's why people hold people accountable. But no, your motion is to. I want a motion. Do you want? Well, when do you want the motion to revoke probation hearing? As soon as possible, you can do it.
Your Honor, we can enter a plea of truth.
She's not going anywhere. I'm not going to release her until I get onto the record all the underlying facts and then I'll make a decision. But you know, this is a tall hill to climb. What do you want to do today?
Well, if
I'm denying the bond.
you're denying the bond, the case is the case in reference that I think it's clear what happened and the result of it. And I guess.
You want some time though to put together something that can convince me that she's not, that she should not be sentenced to the maximum.
We do have
You give a chance.
semi-agreement of the PAP 12 judge.
No, it's gonna be no. No, it's 10. My God, it's 10. The message we send after 10 convictions is No, you're gonna get a break? Oh, my God.
Well, let me
That is
try
a
this.
terrible message to send, especially at Christmas time.
Let me try this option, Judge.
Yeah.
You're not buying the
Do I look like Santa Claus?
I know. In order to push this along,
Yes.
if we, she will enter a plea of truth to the new offense and then ask for a PSI report, so that we could come back here and decide.
Okay.
And based on what you do, then the new offense would, coincide with that.
All right. That's what you want to do.
That's what we want to do.
Is that right, ma'am? All right. Then we call 22-41231, the state of Texas versus Tierra Norman. There is a motion to revoke probation that has been filed as of December 4th, 2025. You were here with Mr. Burbank, your attorney, and the state's attorney and probation official. First of all, does the defendant waive any additional time she may have under the law to prepare? Because I think she's got a few more days here that she could wait.
Yeah, this offense happened in June of
No, I'm talking about when it
25,
was
and they're
filed.
aware of that.
This was just filed on the 4th, and I give everybody 30 days after a filing to at least be ready for an announcement. But if you want to waive any additional time that you may have under the law for a preparation, Mr. Burbank, on behalf of the defendant, are y'all ready to move
Yes.
forward? And does the defendant waive any additional time she may have?
We do, and we
prepare.
ask to proceed. I believe that what we're going to do on comp one, which is saying.
All right, raise your right hand, ma'am. Do you solemnly swear or affirm any statement you made during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? You have to speak out so we can hear you. May we proceed in summary? This should be the form of reading. In summary, this motion to revoke probation alleges that on November 21st of 2024, you were sentenced to 2 years in the state jail, and that was probated for 2 years in this criminal district court of Jefferson County, Texas. If you sentenced to 2 years in the state jail, probated for 5 years for the state jail felony of theft of service. Is that all true?
Yes.
Allegation 1 states you committed the offense of theft of property on or about June 30th, 2025, in violation of your probation order, which is what is represented in this new indictment 25 CL 1242, where you're charged with the state jail felony of theft of property. And I believe this is from the Dillard's department store in Beaumont. Is all of this true and correct? Are you pleading true to this allegation voluntarily and because it is true as it is alleged?
Yeah.
You understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation by preponderance of the evidence or greater. Your probation can be revoked, and you could be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. We're going to order an updated report from probation. We will return back on January.
It'll be either the last week of January or first week.
Can we get the last week in January?
Yes,
Yeah.
as fast.
Please. Okay.
Yeah.
All right. And then all parties can add anything else you wish. Court will make its decision, and then we will take up the other case and see what direction that the pending criminal case for which the new motion to revoke probation is essentially based upon, what direction that may take. Do you understand what has happened today, ma'am?
Yes.
What is your plan on living honestly from here on? Are you committed to doing that?
Just trying to do things for my baby.
But it's still stealing. I know you, but hold, let me see this. Yeah, hold on. You know, I'm asking you to be straight with me, but don't blame your little baby. I mean, your convictions date back 12 years. How old was your baby then in 2014? You can't blame it on your baby. Yes, you did. These things.
It was basically toys for the child.
Yeah, I know, but what happened in 2004? I mean, we got 9 convictions ago. What was the reasons for those? You know, there's always a reason you can find out, but you have to follow the law. And it's just material stuff, I know, but.
How old was your child?
I have 5, so my first one was.
Well, are you stealing to, you've got 9 convictions because you were getting toys for your kids? All of those? No, we know better. Right, we'll see you. Okay, Ezekiel Johnson.
Yeah, she's not stealing for her kids. She's stealing because she likes to steal. That's just my opinion. Feel free to disagree with me in the chat, but I don't think it has really anything to do with the kids, especially since she's not stealing food. But even then, you know, there are other ways to do it than to steal. I'm just saying. Let's change it up. Let's go to Florida. We'll see what's going on with Brantley Clark's court.
Of methamphetamine and 1 count of possession of a controlled substance. Adjudication will be withheld. He will be sentenced to 24 months probation to run concurrent with each count. Court costs and fines at the regular rate, 100 hours of community service at a minimum at 8 hours per month. $20 cost of supervision. He will undergo a drug and alcohol evaluation and counseling if recommended, and submit to random UAs. He must enroll within 30 days. It says time served on the misdemeanors, but there aren't any. There will be a DNA sample, forfeit any seized items. The defense stipulates to the facts for purpose of the plea, and he understands that there is a cost of prosecution. He may substitute the community service for NA meetings or equivalent at a rate at 1 meeting per hour.
That's the agreement with the state?
Raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do. Mr. Norton, you can lower your hand and state your name.
Chris Norton.
All right, Mr. Norton, you heard the announcement of Ms. Bennett. Is that correct?
Yes.
Is that your understanding of the agreement with the state?
Yes.
Has anybody promised you anything different?
No.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No.
I've been handed a plea waiver consent form. There's the front. On the back's a signature of the defendant line. Is that yours?
Yes.
Have you had the opportunity to read that agreement?
No.
Pardon?
What do you say?
Have you had a chance to read this agreement?
Yes, I did.
You had a chance to go over your case with Ms. Bennett?
Yes.
Have you had sufficient time to speak with Ms. Bennett about your case?
Yes.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by entering the plea, you're waiving your right to go to trial.
Yes.
You're waiving your right to require the state prove the allegations against you.
Yes.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes.
You're waiving your right to present any defenses that you might have to these allegations.
Yes.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes. Yes.
All right, you're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Yes.
You're waiving your right to appeal anything but an illegal sentence.
Yes.
Are you doing this of your own free will?
Yes.
Norton, do you feel the pleas in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes.
I am going to accept the stipulation, find there's a prima facie case, and we'll find that Mr. Norton's plea was freely and voluntarily made after consultation with his attorney, and I'm going to accept it. I'm going to withhold adjudication of guilt as to count 1, possession of methamphetamine, and as to count 2, possession of a controlled substance. On each of those, he's placed on a term of probation not to exceed 24 months to run concurrent with each other. He's assessed fines and costs of $1,078. There's no restitution applicable. He must complete 100 hours of community service work at a minimum of 8 hours a month to the Bay County Work Program. I will give the Florida Department of Corrections the discretion to amend that to at the direction of a probation officer. He may substitute community service for NA meetings at the rate equivalent of 1 meeting per hour. His cost of supervision will be $20 a month. He must undergo a drug and alcohol evaluation within the next 30 days, follow all recommended counseling, and zero tolerance for use of any controlled substances not prescribed by a treating physician. He'll be subject to random UAs at his own expense. If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. And if I fail to say it, the sentences will run concurrent with each other. Mr. Norton, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you. You need to step over and speak to the probation officer.
All right, thank you.
All right, let's stay in Florida, but go over, see what's going on with Wade Mercer.
Corporal.
Yes, sir.
Perfect. The first person that has friends or family here would be Shay Skeen.
Ms. Skeen?
Ms. Skeen, good morning. Ms. Skeen, your mother and your friend and coworker Anthony are both here. Ms. Skeen, you're here because you've been accused of one count of driving under the influence, ma'am. There is probable cause in the complaint, Ms. Skeen. I'm going to appoint the public defender's office to represent you. I'm going to ask you to listen to Mr. McDaniel, and we'll see where we go from there. Mr. McDaniel.
Your Honor, Ms. King, she's locally, she works at the post office, been there for the last 6 years. We just asked the court to either, give her a conditional release or a cash bond, whichever the court chooses.
Okay, Mr. Mitchell.
We wouldn't have any objection to a conditional release if the court wants to give her that.
Yeah, Ms. Skeen, I see an old DUI 14 years ago in Bay County, and then a domestic violence charge in 2015 that may have been dismissed. I think that's the most recent thing that I see.
That's a condition release. I probably should clarify, maybe a cash bond, Your Honor, if Your Honor's acceptable or.
Any objection to a cash bond?
No objection.
Ms. Skeen, I'm going to set you a cash bond of $250 cash. Ma'am, you've got the right to post the bond. You'll be released immediately if you post a $250 cash bond. Your bond has a condition that you not possess or consume alcohol, but since this is allegedly not an alcohol-related DUI, you also have a condition that you not take any medications that you don't have a valid prescription for. So what that means is if you're drug tested and you have something in your system that you don't have a valid prescription for, then that would violate the terms of your bond. Ms. Skeen, the other thing is that I'm not sure about the status of your driver's license. I put a condition on DUIs that you do not drive a motor vehicle unless you have a valid license. So since there's no breathalyzer in this case, I think you probably still have a valid license as of right now. If DHSMV revokes your license, obviously they have to notify you. And at that point, you can't be caught driving, can't be driving if your license is revoked. Ms. Skeen, you're going to get out of jail as soon as the $250 is posted. Now, your friend Anthony wanted to speak this morning, but given that it's a cash bond and you're going to be released, I don't know if you want him to say anything. You want me to hear from him or not?
No, I don't think there's a need for.
Okay.
If
so, let me
maybe the
see
only question she has if someone's going to pay that for her or
So your mom says yes, they're going to get that paid, ma'am. So, ma'am, it's $250 cash. As soon as it's paid at the jail, she'll be released. The jail's also going to give her a notice for her next court date. Your court date will be January the 5th, I believe, at 9 a.m. And they will give you that written notice before you leave the jail. So let me see if anybody in the courtroom has any questions. Ma'am, in the back, do you have any questions, ma'am? Sir, do you have any questions?
Yes, I actually do.
Okay, what's your question?
My question is, number one, she has a prescription for Xanax. Number two.
Okay, that's not a question.
Going into the facts.
It's not a question. Listen to me. That's not a question. And it doesn't matter how many prescriptions you have. If you stop talking a minute, I'm talking. Stop talking. I'm trying to address your concern. It doesn't matter if you got a prescription or not. If you're under the influence to the extent your normal faculties are impaired, you can't drive. So if you look at a Xanax bottle, it says this may cause drowsiness, do not operate vehicles on the bottle. So it's not a defense at all. If that's not a defense. You seem to be under the impression that's a defense. It's not. Okay. Do you have any questions?
What was the original reason for her being pulled over?
Okay, that's a fair question, and I'll try to answer that.
I think it was
the law enforcement officer says, Mr. Mitchell.
I think it was reports of she had been driven off the road or something like that.
They got calls that they were driving in, she was driving into oncoming traffic and had forced another motorist off the roadway. Then the officer got behind her. And after the officer got behind her, the officer says that he had personally observed failed to maintain a single lane of travel by leaving the roadway and driving into designated parking spaces along the east shoulder. The vehicle then crossed the center line and entered the southbound lane of Highway 71. Any other questions?
Is it possible?
Judge, I'm gonna just object to this because
Well, he's
we're not
here for
asking
her. If you don't want me to hear from him, I won't. You don't want me to hear any more from him?
I mean, we just want to know if someone's gonna bond her out. We can discuss that later and she can discuss that with him later.
My question for you, Your Honor.
You don't have any, they don't want you to hear any from more. You're hurting her. She's not getting an RR on a DUI where she's allegedly driving into the oncoming lane. Post the cash bond, you'll be released. Your mother's gonna take care of that for you. Have a good day, ma'am. Have a good day, sir. Next case that has friends or family here is Timothy Collette. Mr. Collette, good morning. Mr. Collette, you're here for first appearance accused of one count of criminal mischief. Mr. Collette, I believe you're being brought up to possibly try to resolve this case. Your mother is in the courtroom, Mr. Collette. Listen to Mr. McDaniel and we'll see where we stand.
Your Honor, he's going to enter a plea of no contest to the charge in 25-578 MM with the understanding he'll be placed on probation. Part of the probation is he has to complete CREMO and any aftercare, anything associated with it while he's out there. And this is it have to be accepted by the court, and this will resolve this case. And once he's done with everything, the case is over with. There'll be nothing to follow. I think the fines will be $370, which he'll work off while he's at CREMO doing some kind of public works. And he has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Mr. Mitchell.
That is agreeable with the state, and we have been in contact with the victim, Miss Collette, in this case, and that is agreeable with her also.
Thank you. And just to clarify, Miss Collette's the mother of the defendant, but she's also the alleged victim. So, Mr. Collette, did you hear that agreement, sir?
Yes, sir.
Mr. Collette, do you have any questions about that agreement?
No, sir.
It's 1129. It's a first degree misdemeanor. It's more than $200 alleged. Is that the plea you would like to enter, Mr. Collette?
Yes, sir.
Mr. Collette, I'm going to accept your plea of no contest to the charge of criminal mischief, a first degree misdemeanor. I'm going to withhold adjudication of guilt in that case, Mr. Collette. I'm going to sentence you to 11 months and 29 days probation. You will have the standard conditions of probation. In addition to the standard conditions of probation, Mr. Collette, you will have a special condition that you successfully complete inpatient drug or alcohol treatment at the CREMO program here in Mariana. Mr. Collette, that will, you'll get a chance to work off community service through that. If you complete that program, and you complete the aftercare, then you may be eligible for early termination of probation. Mr. Collette, if you leave that program, that violates your probation. If you get kicked out of the program for violating rules, that would violate your probation or could violate your probation. So, Mr. Collette, let me ask Mr. McDaniel as far as a start date. I know that at one point they had a waiting list. Mr. McDaniel, can we tell him or his mother when he may be going? What's our estimate?
Yes, Your Honor. I talked to Fred this morning and he can go today. He's got enough room for him. So he'll be, we're going to have probably the chaplain take him over there today. So whenever this order is done.
Let me see if Ms. Collette has any questions. Do you have any questions, ma'am?
Yes, I would like to ask, once he gets settled and everything is done and they allow visitors, I can go visit him, right?
There's not a condition of no contact that we're installing. Now, CREMO has its own rules and the jail has their own rules. So the jail has the rules of no contact with the alleged victim. And then I have no idea what CREMO's rules are. So that's up to them. But there's nothing in, there is no condition, no contact in the sentencing because you're not requesting that condition. Okay. Mr. Goodson.
Just to let the mother know, Your Honor, that they do have a condition of no contact with outsiders for a limited amount of time. I'm not sure how far long that is. So there'll be limited contact. And Mr. Collette did wanted to ask his mother if he would bring some of his belongings.
I'll be able to call her. Tell her I'll be able to call her and then she'll be able to bring some stuff.
So he'll give you a call this morning. If you can bring it up here before he leaves over there, he'd appreciate it.
She can take stuff over there.
Or drop it off there, I guess.
Okay. Okay, Mr. Goodson.
So I guess the jail will bring him up this morning. He'll be instructed and then
correct.
He will go straight from the facility to from the correctional facility to the inpatient treatment program, correct?
Yeah. Now, whether he goes from the courthouse after getting instructed and gets dropped off at CREMO on the way back, or whether he goes back to the jail and gets transported from the jail, that's up to them. But he definitely needs to be instructed on the probation after first appearance, corporal, and then go back to either CREMO or the jail. He's got to be instructed on the terms of his probation before he goes to CREMO. Mr. Collette, do you have any questions?
No, sir.
Not, sir. Wish you the best.
And Your Honor, I will put on there is no request for restitution in this one.
Thank you. We have Mr. Davis. We're going to do that one last because that one may be lengthy. That's a sentencing. So let's go back to Eugene White, the top of the list. Good morning. I'll give you time to sign whatever you're signing before we get started. Good morning, Mr. White. You're on a fugitive warrant out of the state of Colorado. You just signed a document in front of me. I'm going to assume that was a waiver of extradition, sir. Is that correct?
Yes.
Mr. White, do you have any questions about that waiver of extradition process?
Not really, but I mean, this ain't my, I don't see how I would charge for it.
No.
No questions.
Okay, so Mr. White, they'll pick you up within 30 days, but I review the cases at 15 days to see where the transport's at. So if you're still here in 15 days, you'll come back to first appearance and you'll hear what I hear when I ask what the status is. But they have a hard deadline of 30 days. That deadline starts when you sign that waiver in front of a judge. So it starts today. If they don't pick you up within 30 days, you'll be released. Also, considering that it's Colorado and that's quite a ways from here, if they contact the jail contacts them today and says he's ready to be picked up. They'll do that in writing. If Colorado then says, hey, we took a closer look at the case, we're not coming all the way to Florida to get him. If the Colorado does that, which happens from time to time with states that are quite a ways from here, if that happens, you'll be released immediately. If they send us something in writing saying they don't want you. Otherwise, I'll see you in 15 days if you're still here, okay?
All right.
Have a good day. We have Cody Clemens next. Mr. Clemens, good morning. Mr. Clemens, you're here because you've been accused of violating the terms of your probation in case 22-441 CF. Mr. Clemens, I've got a copy of the warrant in front of me. It's signed by Judge Garcia. It has no bond on it. So, Mr. Clemens, what that means is that you're going to be held with no bond until you can see Judge Garcia. I want to get you arraigned today because I want to get you a lawyer appointed if that's what you're asking for. Mr. Clemens, would you like to have an attorney appointed to represent you in the VOP?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Mr. Clemens, listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, we're going to enter plea of not guilty. We're going to ask to set this on January 8th, and Mr. Green or public defender will come by and visit him prior to that hearing.
Thank you, Mr. McDaniel. Mr. Mitchell, anything from the state?
I just wanted to give John and the court a little bit of extra information regarding that he currently is on probation for the charges out of Houston County, Alabama, but he's got a warrant out there for absconding, which, you know, according to the information that I received. So there may be a warrant out there for violation of state probation in Alabama also. That may be information that John can pass on right there.
So, Mr. Clemens, what will happen is at some point before you release, the jail has to do a warrant check on you for other states. So if that does come up at that point, we have to hold you for them, but you need to be aware of that when you're talking to your attorney in the Jackson County charge, because that's possible. Mr. Mitchell's been advised of that. All right. Thank you, Mr. Mitchell. Mr. Clemens, wish you the best. I think the last case we have is Israel Davis. Mr. Davis, good morning. Mr. Davis, you're here in case 24258MM. You're accused of violating in terms of your probation, Mr. Davis. I believe you were arrested a couple of days ago, and we passed your case till today to give you and the state and defense time to try to figure out where we stand. So I'm going to appoint the public defender's office to represent you. Mr. Davis, I'm going to ask that you listen to Mr. McDaniel. I also want to tell you that your wife is in the courtroom. Mr. McDaniel.
Your Honor, we're going to admit that we violated the probation. At this point in time, he has 20 days jail credit and just asked the court to sentence him on that.
He has how much credit?
20 days.
20. Mr. Davis, I need you to raise your right hand, please. Mr. Davis, do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Great. Mr. Davis, I've got to explain a couple of things to you. The first is that you're accused of violating the terms of your probation. You have the right to a violation of probation hearing. If you exercise that right, we'll have a hearing. You'll have an attorney appointed to represent you. Very well, maybe Mr. McDaniel, but that attorney would have the right to cross-examine witnesses on your behalf. We'll also have the right to call witnesses on your behalf. the state would be trying to prove that you violated your probation in a material and substantial way, and we would have that hearing. But you need to understand, if you enter this plea, there will not be a hearing. You're waiving that right to a hearing. You're also waiving those other rights I mentioned, which are calling and cross-examining witnesses. You understand all of that, Mr. Davis?
Yes, sir.
The other thing you need to understand is the maximum sentence for this charge. Well, there's two different charges. The maximum sentence for the resisting without violence is 1 year in jail. The maximum sentence for the driving while license suspended is 60 days in jail. So basically the maximum I could sentence you to is a year. I'm not saying I would do that or I intend to do that. I'm saying I have to advise you that's the maximum. Knowing all of that, you still want to enter the plea of admission that Mr. McDaniel just placed on the record?
Yes, sir.
Okay, I'm going to accept your admission that you violated the terms and conditions of your probation. We're going to move on to sentencing then. We'll find that admission is freely and voluntarily entered with the advice of counsel. As far as sentencing goes, so the allegations, Mr. Goodson with the probation office is here. The allegations are that you were put on probation July 1st of 24. So 7/1 of 24, put on probation for 6 months on one case, 11 months and 29 days on the second case. Then October 2nd, which is 3 months later, you're accused of violating your probation. There's 3 things alleged. The first is that you never paid anything towards cost supervision. Is that right, Mr. Goodson?
Yes, sir.
The second is that you never paid anything towards court costs and fines. Is that right?
Yes, sir.
And the third allegation is that starting in September, you stopped reporting, that they didn't see you. So that would mean that I'm guessing Mr. Goodson, he must have showed up in July. If you had a reporting period in July, showed up in August, and that was it.
Yes, sir. Can I?
Let me get this first. I'm trying to give you that. So my first question is, did he report in July, or was there not a reporting period in July? I'll give you a chance to say anything you want. I'm just trying to make sure I understand factually where the allegations.
On July the 18th, his aunt had called me. His check-in day was July 20th. His aunt on July the 18th, Sharita Wright, called and said she had filed a Marchman Act against Mr. Israel Davis, who is her nephew. On July the 29th, he had the Marchman Act, and his aunt brought him downstairs after the Marchman Act. And I told him he had to check in with me on the 20th of each month, which started in July. And he did check. So I assumed that would be a check-in for June, because he came down on the 29th, which was 9 days past the 20th. He checked in on August 20th and said he would pay later, and I have not seen him since.
So he's supposed to check in on the 20th of July. It's not on the affidavit because he checked in 9 days later.
I gave him credit for, he did come in on the 29th. Yes, sir.
Okay. All right. So those are the allegations. That's what you're accused of. Now, Mr. McDaniel, if you'd like me to hear from you or from Mr. Davis, either way, it doesn't matter to me.
I'll just make a statement at first. I'll make a statement. I've asked the wife maybe not to say too much at all, but I'll just make a statement, Your Honor, that, and I'll let him, I'm sure you have questions for him. He was court ordered by Judge Patterson in August that he had to go to a rehab. He did go to that rehab. And it was a dual diagnosis facility where they were giving mental health medications and drug rehab. He didn't get out of that facility until February of this year. So between February and then June, he was picked up in Calhoun County. He's been in Calhoun County since, the first part of June. So it was about a 4-month span there. And I guess I suspect the logical question is, what happened between those 4 months and why he didn't, report in the probation. And I suspect that's a question you have to ask Mr. Davis.
I'm confused though. Before we get to that, what was he in Calhoun County for?
Child support.
Okay.
He showed up at a
It
hearing.
wasn't.
He showed up at a hearing.
So there's no allegations of a new criminal case while he's on probation,
No.
Correct? Okay.
That was a
All right,
hearing
so-
scheduled. He showed up for that hearing, appeared at the hearing, and went through the hearing in Calhoun County. That's when he was advised that he had a warrant for him in Jackson County, and he was taken into custody in Calhoun County.
Okay, so you're put on in July. I'm looking, Mr. Davis, at the mental health case that Mr. McDaniel referenced. So there was a petition in that case. July 1st was when you were put on probation. July 24th is when the petition for involuntary treatment was filed. I'm trying to see when you were ordered or committed or what was done in that case.
And
July
Judge,
29th is, go ahead, Mr. McDaniel.
I went through that case, and it's very, I just don't think it's, it's just not complete, I don't think, because it's very weird how I never really seen clear orders on them, but I can clearly see that the mental health place had discretion to put him into a rehab, and I know that's what happened. I seen all those orders to appear and stuff, and orders show cause while he was at the rehab. So I'm not sure if they weren't telling Judge Patterson everything that was going on. I'm really not sure. It was very unclear when I went through the record.
Okay, so that there is an order. Let's see what this one is. This is signed by Judge Patterson on August the 9th, which would have been a little bit over a month after he was put on supervision. And what this says is that he's lost power of self-control due to substance use and is in need of substance abuse services, and that's impaired his judgment. He's incapable of appreciating his need for services. And he is to report to CARE outpatient treatment facility, and CARE shall give a report. So that was August 9th. Let's see what happened after that. He didn't, apparently, according to the court file, he didn't go like he was supposed to, because there's an affidavit filed by the CARE facility which says he didn't show up for his treatment plan. So let's see what happened next.
At that point in time, he was already at the rehab that they had sent him to. That's why I say it's kind of weird.
So we rehab, who had sent him to?
CARE I guess they didn't, like, they weren't communicating very well. They had already sent me the part.
Give me some dates. Give me some dates, Mr. Davis, to help me understand. When did you, so there's a court order saying the judge is for you to go to CARE. Did you go or not?
I got sent to Bartels. I got sent to Bartels, the CARE over there in Panama City. They took me in there for, I think, 3 days. And then I got sent to.
When was this, Mr. Davis?
This was in, I believe this was in August. This was in August, and whenever I completed that at the CARE detox, because you got to go there before you can go to Bartels. And once I got to Bartels.
Let me interrupt you. I don't know what Bartels is. What is Bartels?
It's a facility that's a part of CARE. It's it's the same kind of like Chrome and Aware and Bartels. They're all a part of CARE.
And where's that at?
That's in Panama City.
Okay, so go ahead, please.
All right. Once I got to Bartels, Judge Patterson sent a letter over there for a Zoom court to make sure I was there and to make sure that I stayed there. And I did that Zoom. And then later on in November, well, later on in September, he scheduled another Zoom to make sure I was there. And then once it hit November, he scheduled I was supposed to be released in November, but he extended it to the halfway program to February. So I was there until February after that point.
Okay. So then the question is, February 25, you get out and you have not reported to the probation since the previous July or August. So what happened in February? Now that you're better, you've been to treatment, why don't you report to your probation officer then and say, here's what's going on, here's where I've been?
Once I got out, Your Honor, everything completely like crossed my mind because how long I was there. And right when I got out, my wife had twins, and one of the twins, I was helping her with it, but one of them had problems with communications and it died a month later. And after that point, it was like I had to pay fines for the funeral and everything on the certificate and all that. It just crossed my mind, Your Honor. I was just asking for a second chance.
Were you working?
Yes, sir. I ended up getting a job at Southern Lumber.
How long did you work there?
I worked there from, I want to say the end of February all the way up until my arrest date in June till Calhoun County. I had to go to court in Calhoun County, but I kept that job until then.
Okay. Mr. Davis, before I hear from Mr. Mitchell, anything else that you think I need to know that you want to tell me?
Anything you want to tell him? I mean,
if I could just get a second chance, please.
That's what you were asked for that. So. Anything else?
That'd be awesome.
I'm going back and looking at the original complaint to see what the resisting was about. Was it a running or a physical resisting?
I don't think it was much, just based on the initial offer at first appearance of the case, and that's just going off my thought.
Or can you read out the complaint? I'm having internet
Yeah,
trouble right now and I can't look it
I
up.
think Mr. McDaniel may be accurate. After a brief conversation between Davis and Lieutenant Davis refused to provide me with identification. At that time, Davis was removed from the vehicle due to Davis having an active warrant. An attempt was made to place Davis in handcuffs. Davis began to physically resist, tensing up and trying to refrain from being restrained and having his hands placed behind his back. Lieutenant unholstered his taser, and at that time, Davis placed his hands behind his back. Let me see if there's anything else in there. After continuing to request identification, it was determined that a false name had been provided.
That was the second guy.
That wasn't you, that was someone else.
Yes, that was another guy in the vehicle. I'm sorry.
Okay. So the resisting consisted of this: due to Davis physically resisting officers by tensing and pulling away while being lawfully restrained, Davis is charged with resisting without violence. Mr. Mitchell, anything else?
I don't have any input at this time.
Mr. Davis, I'm going to sentence you to time served. So I'm going to accept your admission that you violated terms of your probation. I'm going to sentence you to time served due to that. The allegations are, had you ran from police, had they had to get a dog after you, had they find you hiding in somebody's basement or attic or whatever, but tensing up while they're trying to handcuff you, considering that you've already done 20-something days in jail, I think that's sufficient punishment, especially given the mental health issues and the loss of your child, which I'm sorry to hear. So you're going to be sentenced to time served. Now, that means you're through with this case. As long as you don't have any other holds, then you'll be released today. The jail will do a warrants check on you, Mr. Davis. We'll see if there's any other warrants out there. Mr. Davis, I do have to order court costs and fines. So any unpaid court costs and fines, there'll be a judgment for that amount. That would be $370, I believe, that you do not get paid on probation. So there'll be a judgment for that amount. If you don't get that paid or work on a payment plan, then the clerk's office will suspend your driver's license after a period of 90 days. 90 days. So that means that when you get out, you may want to contact the clerk of court and start a payment plan on that court costs and fines to keep your driver's license from being suspended if you have a driver's license. Mr. Davis, do you have any questions?
No, sir.
Mr. Mitchell, I should have given you a chance to have input, but I know,
I mean, it wasn't
based upon the other cases we have with that type of resisting, I kind of figured your approach. Was there anything you wanted to add?
No, nothing else.
Okay. Mr. McDaniel, anything else?
Just remind his wife and him that he needs to get back to work and he needs to be paying that child support in Calhoun County, or they'll be seeing him again in Calhoun County very shortly. I know he was working when I seen him in June, so he needs to get back to work.
So, ma'am, thank you, Mr. McDaniel. Ma'am, he'll be released. They process him out. Usually processing takes 30 to 45 minutes, probably not even that long, probably 20, 30 minutes. He'll be processed out and he'll be released. Keep him out of trouble, okay? Go to jail, pick him up. Wish you the best, ma'am. If you want to go downstairs while you're here and set up a payment plan for him, that'll be done and out of the way. And they'll stretch that out up to a year. The clerk's office on the east side. On the east side, which is facing Jackson County Times. It'd take him time to process them out anyway.
Yeah, I thought I recognized
You remember him?
Yeah, I
You
remember.
probably remember his photo, Marcus.
Yeah, I remember.
Thank y'all so much for this.
Thank you, ma'am. Merry Christmas. Mr. McDaniel, that's everything I had on my list. Anything else from the Public Defender's Office? No.
All right, friends, since they've wrapped up there, I'll take a few minutes here to discuss a couple things. First, thank you, Grandma TCF, for gifting 10 memberships. Undoubtedly, you're financing that with the reclaimed gold from the tooth you had pulled the other day. So thank you for paying it forward to the channel. Very much appreciated. So speaking of the channel, starting in the new year, there will be some things that will be different. And this will be effective Monday, the 5th of January. That'll be the first day that we're back in the new year, fully live. By the way, while we go through the next 2 weeks of the holidays, it'll be a combination between live show and best of. There'll be something every day in this time slot. It'll just kind of depend on what's available for courts as to which way we go. But there'll be something here every day for you, so be sure to tune in. But starting in January, this channel is going to shift its focus just a little bit into becoming completely driven by the live content. I'm of the opinion, and I've consulted with a lot of you who watch regularly, and you're also of the opinion that the live content is the best product that we have to offer here at TCF. And frankly, there's a lot of people out there that just post videos. So we're going to focus on the live here. And what will happen is that this show will actually expand to 4 hours. We will be starting an hour earlier. So 9 a.m. Eastern, 6 a.m. Pacific, starting January 5th. And the 4th hour will be something completely different from just watching court. So more on that to follow. You'll see once we get there, but it'll be fun. It'll be a lot more interactive. It'll be different from just, again, sitting here and watching court. We're going to do some different things, and I'm really looking forward to that. And the videos that we post and the shorts that we post will all be derived from the live show. So we'll clip content from that and make that accessible to more people that way. And that's what we're going to focus on for 2026. I've told you before, the mission here is to grow this community, and I feel like that's the best way to do it. So that's where our focus will be. But again, starting January 5th, the show will start at 9 a.m. Eastern, 6 a.m. Pacific, and it will be 4 hours long. And by the way, for members, the pre-show will return as well starting January 5th. It'll be 30 minutes, not 45. So that'll start at, 8:30 Eastern, 5:30 Pacific. So getting an early start, but court starts early, so we're going to line up with it. So that's what's going on. If you got questions or anything about that, feel free to put it in the chat. Let's go back to Judge Stevens.
Last night I completed mine for last year. I just completed it for last year, and I'm working on this year from here on. We now call 15-21847, the state of Texas versus Edward Joseph Otremba. You're Mr. Otremba.
Yes, sir.
Present with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation, which was filed when I was just a child, August 10th of 2016? Had he been an absconder? He'd been an absconder, okay. And can we proceed in summary? This is rare. These are rare, but they happen. Okay, he was reporting, and then in 2016, he quit reporting, and then he was an absconder, which means he was kind of on the lam there. This was filed August 10th. There was a warrant out for him for 8 years. When was he arrested? Where have you been for 8 years?
I'm living the same address in Houston, Texas, sir.
Okay. Nonetheless, you're supposed to come to us. We don't have to come to you.
It's been October the 16th of this year.
Okay. So that was over 9 years. You had absconded. All right. And does he waive a formal reading? We can proceed in summary.
Yes, Judge.
In summary, this motion to revoke unadjudicated probation alleges that on February 8th, 2016, and by the way, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
That on February 8th, 2016, in this criminal district court, you were placed on deferred or unadjudicated probation for forgery. Is that true?
Yes, sir.
Let's see. Is it state jail felony?
Yes, sir.
Yeah, state jail felony. Yeah. Allegation 1 states that you failed to report to the Jefferson County Probation Office upon release from, oh, you never reported.
No, sir, he was released in June.
You were released on June 7th, 2016 from the jail, and you were required to report immediately, as all prisoners from who were in custody, who were released and placed on probation, to report immediately or as soon as possible thereafter. And that was over about 9.5 years ago. You failed to report on or about June 23rd, 2016, July 5th, 2016, July 13th, 2016, and was not heard from by the probation office. And all of this is in violation of condition 4 of your deferred or unadjudicated probation order, which states that you must report as directed to the probation office and obey all rules and regulations of the probation office. Is that allegation true and correct as it is alleged?
Only one part of it is untrue. I did make several phone calls to the probation office from Houston while I was in Houston, and I tried to get them to move to Houston, and that was unsuccessful.
Until or unless that happens, it's your obligation to come to them.
I just mentioned the part that was untrue.
Oh, are you pleading true to failing to report to the probation office upon release, as this is alleged, voluntarily, and because this is true as it is alleged? Yes.
He was dead.
Yes, I'm asking, is this true and correct as it is alleged, except for the part that you're talking about? You failed to report as required, and you have absconded or failed to report for 9.5 years.
Yes, sir.
You're pleading true and correct in that voluntarily and because it is true. Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is all it takes to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced no less than 180 days up to 2 years.
Yes.
In the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Mr. Turk, as Mr. Otrumba's attorney, what do you want to add here so the court can make an understood and knowingly made decision on his fate?
Judge, I mean,
looking at how much time, it looks like he has 205 days credit.
Okay.
Already, which is,
Judge, I just want to point out,
over 180 days.
he did make attempts to, albeit maybe not the appropriate level of attempt, but he did make attempts to contact probation over those periods of years to try and get things worked out. He was in Harris County. As you can see, Mr. Trim is not, he's disabled. He did not have transportation nor a support system to get him here to help him do that. And for those period of 10 years, I'm unaware of any sort of issues that he's had criminally. So he's been minding his P's and Q's for that period.
We got a problem though. I mean, there was a victim here and restitution was almost $2,000. Was that ever paid back?
I've made an attempt this week, as you asked last week, sir, to, the person that's going to help me had said that he contacted the court and he contacted the DA and he said both.
He needs to contact the probation office.
And I got the card from the probation officer yesterday and I messaged him from the kiosk in the jail, the information but he said that he's been getting answer machines and all
I never get that. I mean, if he's calls up, no, sir. I never get that.
Yes.
If he's calling at 3 a.m, yeah, but not during the business day. They answer the phones. the courts, the district attorney's office, the probation office. I've worked with them for 20 years. I've never had problems during the business day. So that's dunning. We call that dunning. That's stalling and looking for reasons which don't really exist, that aren't realistic. Look, sir, if you can't get this paid back, which is what we have to do to pay a victim back, the only option I have is to sentence you to what would be the 2 years, which is the maximum. But you have to do something that is worthy of entitlement for a punishment that is less than the maximum. And if you do nothing, there's only, why would you receive less punishment if you've done nothing for 9.5 years? See, that's why you can purge this, and I can consider a much lower sentence. No.
Yesterday or the day before about the restitution. We told them court doesn't take in money.
No, it goes to probation.
Either pay probation or you show.
But what they're saying is our office talked to them and told them what they needed to do is the right thing. I'm telling you, let's go to probation.
We told them that they could show up today with a money order. If they
Okay, show up today with a money order. Did anybody do that? Anybody hear from Mr. Trimble? No. Who is it? Was it family or relative or a friend?
Not to interrupt, but I have to go deal with a couple of things, so I'm going to leave you in Judge Stevens' court for a while, and I'll be back with you as soon as I can.
Do you think they are able to accomplish something for you?
Yes, sir, I do.
All right. Well, I'll give you some time to do that before I make a decision.
Thank you.
Because I just want this paid back. You can get this paid back, and the court's going to be. He's already got 205 days.
I think that's the
minimum's the minimum of this is 180. See, but you pay it back, you get rewarded.
Thank you, sir.
I can week all day long, but I can't tell you exactly what that is, but you can figure it out. You can go home.
Thank you, sir.
But the people have to be paid out who have been harmed, and that's how you do it when there's a loss of money. Pay it back. But even in this case, it's been almost 10 years they've been out that money. And in all fairness, we don't have a situation like in the federal courts where you have to pay interest on a loss. But if there was, it would be doubled by now.
Yes, sir.
But so the quicker it's done, the quicker you can get rewarded. But I'm going to review this in 3 weeks. Is that okay? All right.
Is that plenty of
Just so he doesn't get forgotten about. Okay.
Judge will urge that we get it done as soon as possible.
Thank you. Reset, and his entry of his plea is the court finds it's knowingly and voluntarily made. I'm going to hold that in abeyance until we hear an update on the restitution. Okay, thank you. Betty Handy will be next. Betty Handy. Hey Reagan, how are we doing on Cameron Smith and Maximo Urbina?
They're both pleased, Judge.
Okay, thanks. You're Betty Handy? And you were here with Mr. West, Euroton, and the station. What are we doing today?
I think it's about, it was held in advance last time.
I'm sorry, I can't hear.
It's a review. It's a review. I think it was held in advance last time.
Yeah, okay, she pleaded true in January of this year, right? To allegation 1 and 2. And we continued her on probation. You are Betty Handy in cause number 23-41397. And you were placed on back in April of 2023 on 5 years deferred or unadjudicated probation for injury to a child or a disabled person. And then you pleaded true to failing to report and failing to perform community service hours. We did that back on January 6th of this year, I believe.
Yes.
And here is a review of how we're doing and how are we from probation.
Well, Your Honor,
There's good news.
she last reported to me, this past, November the 4th. I just got her on my caseload back in September. She's got a positive demeanor. She's done.
She tested positive for a good
Positive demeanor.
That's good.
It's in office.
We get too many tests positive for drugs.
That's the only positive we want to hear.
Positive for a good demeanor.
Since I'd say March of this year, she's completed almost 200 hours, 266 hours community service.
She's doing well.
She's doing fantastic.
Oh, wonderful. All right.
And she paid $50 yesterday.
I'm sorry.
She paid $50 yesterday.
She made a payment yesterday.
Why did that cause you to sneeze?
I don't know.
He's allergic to money.
He's allergic to
He's
something.
allergic to paying somebody else but him.
Oh, that would make
Not allergic to
sense.
money, but
Yeah,
allergic to people paying money to other people, yeah.
So here's the important thing, Miss Handy, how do you feel you're doing on this?
I feel I'm doing good.
You're doing the best you can be?
Yeah.
Is you're being the best? Well, that's what we want from probationers. And 93% are successful. 93%. 1 out of 14 fail, on our watch. Because probation office does such a fabulous job. This is greater than the national average of about 75%.
Yes.
So if you fail, it's not their fault. They work hard to try to help people get across the finish line, and they do a great job. It's an honor working with them. But you got to do your own heavy lifting. We'll help you, but you've got to take care of it. And it looks like you're doing a good job. Okay, so what are the what is still left to do other than complete 5 years? We reward people for good behavior and doing well by shortening probation in certain situations. You've been on probation going on, it'll be 3 years in April. So what other things does she need to do?
Your Honor, she needs to finish paying up her fines, court costs and things like that.
How much there's no restitution?
No, Your Honor.
Okay. Fines were 500 and is she behind right now?
Yes, Your Honor, she's behind.
Everybody seems to be.
2820 behind in arrears.
2,820.
$2,820 in arrears.
All right. You have children at home?
Yes, sir.
How many?
30.
Are you the sole provider?
Yes, sir.
How do we shut that rising costs down? Can we put her on a type of probation if she's doing well that doesn't add every month so she can catch up in light of her performance and her situation?
Once she completes her community service, probably, or can we do it while she's?
We were going to send over an amendment to the court to hold the rest of community service in advance. She doesn't have to complete that.
Okay, I'll sign that when you do it.
Okay. I just recommend keeping her rocking along and potentially extension in the future, when we know no necessities at this point.
Well, what can we do about the curtailing that continue? I guess, what can we do? Is there anything we can do? I mean, we would put them on an inactive, but you don't think she's ready for inactive right now? Okay. And so my active, you have to pay for the costs for the supervisory time and effort that they put in helping you complete this successfully, which is worth the money. But I would like to get to a point where she can take care of the household expenses in lieu of unnecessary costs to the probation office, if we can figure that out. What do we want to do?
Say, if you're gonna do that, General, why don't we just, maybe come back in 3 months and see where we're at?
I got a better
Right,
idea. If we just return back in 3 months, we can figure out.
It's a great idea, Judge. Glad you came up with that.
All right. And please get a resetting. Merry Christmas to you.
Keep on doing it.
Keep doing the good work.
We should be ready to go.
All right, I'm back in the chair. I have no idea what just went on in Judge Stevens' court, but I hope it was good. Let's go check back in with Brantley Clark.
99 CFMA. The notes that I have for Mr. Ramey on this case is that the client's out of custody. A waiver has been filed. The trial has already been set for February 2nd, I guess the week of February 2nd. I've been told that there's nothing much that needs to be done. They'll either resolve it by plea or go to trial in February.
All right, we'll just leave it on that docket. All right, February 2nd. Thank you.
Thank you so much, Your Honor. And then the case that I'm here for is also with Mr. White. That is going to be with Madam Interpreter, Ms. Ruiz on Zoom, and Nenser Cubillos Gonzalez.
All right, Madam Clerk, if you'll swear the interpreter in, please.
I always swear that you'll truly interpret the defendant court questions and answers to help you God.
Yes.
Thank you. And where is it on the docket?
Under G, or is it under C? It's under C, Your Honor, Cubillos Gonzalez.
Okay, very good.
And that's going to be case number 24-2015 CFMA.
I've got it. Okay.
All right. We would like to withdraw any previously entered plea of not guilty. I don't know how slow I should go for Madam Interpreter.
Oh, okay. Hello, buenos días, señor. Sorry. Hello, buenos días, señor González. Usted está declarando no culpable.
And in exchange for withdrawing our previously entered plea of not guilty, Mr. Gonzalez would plead to 1 count of criminal mischief.
Okay, usted está declarando no culpable y procedimiento de mala cuenta.
It would be a plea of no contest and adjudication of guilt would be withheld.
Sería una... Espera, hold on one second. Una declaración ante el tribunal de no culpabilidad.
He would be placed on probation for 24 months.
Te van a poner en probatoria por 24 meses.
He would have court costs and fines in the amount of $1,253.
Los costos de la corte serían $1,250.
Sorry, I was being informed that the interpreter may be saying that he's pleading not guilty, and it's not that he's pleading not guilty, he's pleading no contest.
Okay.
Oh, ok, usted no se está declarando que no es culpable, que no va a reclamar el cargo, que no lo va a oponer.
Okay. Lo siento, mi amor. Okay. I believe Madam Interpreter, did we already state that he would be placed on probation for 24 months?
Sí, usted va a ser probatoria por 24 meses.
Court costs and fines in the amount of $1,253.
Los gastos de la corte va a ser de $1,250.
And he agrees to imposition of the minimum cost of prosecution.
Usted está de acuerdo con la persecución.
There is restitution in the amount of $7,500.
Hay otro pago de restitución de 750.
He has credit for 2 days time served.
Te van a dar crédito de 2 días por tiempo cumplido.
There is a $20 a month cost of supervision.
$20 al mes de costo de supervisión.
The defendant stipulates to the facts and the probable cause affidavit for his plea.
Say that one more time, please.
He stipulates to the facts for the basis of the plea.
¿Usted está de acuerdo con lo que le están diciendo la corte, la declaración ante el tribunal?
He will submit to a DNA sample.
Usted tiene que hacer una prueba de DNA.
He will forfeit any seized items.
Usted tiene que devolver cualquier artículo.
He will have no contact with any victim.
Usted no puede tener ningún contacto con las víctimas.
And count 1 will be consolidated.
Y la parte 1 de la plea va a ser consolidada.
That's the plea in total, Your Honor.
Very good. That's the agreement with the state?
Yes, Your Honor.
And I'm passing up the signed plea form, the court cost, and the score sheet, Your Honor.
Raise your right hand. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Levante la mano derecha. Usted jura ante la corte que todo lo que se ha dicho es verdad.
Sí, lo juro.
Yes, I swear.
Sir, you can lower your hand,
¿Puede bajar la mano?
state your name.
Diga su nombre, por favor.
Nancer Uriel Cubillo González.
Mr. Gonzalez, you just heard the announcement of Ms. Smallwood. Is that correct?
Usted escuchó lo que la defensor público le dijo.
Sí, sí, señor
Yeah.
juez.
Is that your understanding of the agreement with the state?
¿Usted entiende el acuerdo que está haciendo con el Estado?
Sí, señor.
Yes.
Has anyone promised you anything different?
¿Alguien le ha prometido algo diferente?
No, señor.
No.
I've been handed a plea waiver and consent form. I'm going to show it to you at this time. That's the front page. On the second page is a signature over the defendant line. Is that your signature?
Esa es a él le dieron una declaratoria ante el tribunal. ¿Esa es su firma? ¿Usted firmó eso?
Sí, señor.
¿Sí?
Yes.
Yes.
Have you had a chance to go over that agreement with Ms. Smallwood?
¿Usted ha tenido la oportunidad de revisar esos documentos con la señora del lado?
Yes.
Smallwood? Yes.
Have you had enough time to speak with Ms. Smallwood about your case?
¿Ha tenido bastante suficiente tiempo para hablar con la señora Smallwood?
Sí.
Yes.
Are you satisfied with your lawyer's advice and counsel?
¿Usted está satisfecho con usted está satisfecho con lo que le dijo la abogada?
Sí.
Yes.
Do you understand that by entering this plea, you're waiving your right to go to trial and you're waiving your right to require the state prove the allegations against you?
Usted entiende que usted aceptando esta declaración ante el tribunal, usted no tiene derecho a entrar al juicio de los tribunales.
Sí.
¿Aceptando esto? Yes.
Sí.
You're waiving your right. Have your attorney cross-examine the state's witnesses and contest their evidence and to present any defenses you may have to the allegations.
Usted renuncia, sabe que está renunciando a sus derechos para presentar alguna evidencia ante el juicio tribunal.
Sí.
Yes.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Usted sabe que va a renunciar, que no puede presentar ningunos testigos ni su declaratoria.
Sí.
Yes.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Usted sabe que va a renunciar y tiene que mantener en silencio en el tribunal.
Sí.
Do you understand if you decided to go to trial, you'd have an interpreter the entire trial?
Usted sabe que si decide ir al tribunal, va a tener un intérprete todo el tiempo.
Sí.
Yes.
You're waiving your right to appeal anything but an illegal sentence.
Usted sabe que usted renunciar todo menos una sentencia ilegal.
Sí.
Yes.
You're waiving your right. And are you doing this of your own free will?
Usted está haciendo esto con su propia voluntad.
Sí.
Yes.
Mr. Gonzalez, do you feel the pleas in your best interest?
Usted está viendo que todo esto es para su mejor interés, lo que está declarando el tribunal hoy.
Sí.
Yes.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering this plea.
Usted sabe que si está en una situación de deportación, aceptando esto, puede ser deportado.
Sí.
Yes.
I'm going to accept the stipulation and find there's a prima facie case. I'm
Él va a
going to find that Mr.
Sorry.
Go ahead.
Él va a aceptar
Good.
su caso. Lo que la declaración ante el tribunal, él lo va a aceptar.
I'm going to find that Mr. Gonzalez's plea was freely and voluntarily made after consultation with his attorney, and I'm going to accept it.
Él lo va a aceptar como que usted entiende y lo hizo voluntad propia.
Adjudication of guilt is withheld as to the criminal mischief more than $1,000.
El delito va a ser más de $1,000.
He's placed on a term of probation not to exceed 24 months.
Lo van a poner en probatoria por 24 meses, no más.
He's ordered to pay fines and costs of $1,253.
Va a tener tarifas y fianzas de más de 2,400. More than 2,450, you said?
$1,253.
$1,253.
He's going to pay restitution amount of $7,500 to Win.
I'm sorry, what's another word for that?
Just say Mr. Wynn.
Mr. Win.
Usted le tiene que pagar $750 a Mr. Wynn.
His cost of supervision will be $20 a month. He must, if he's required to give a DNA sample, he must submit one. He'll forfeit any seized items and have no contact with the victim.
Ok, usted tiene que pagar $20 al mes. Va a tener que también hacer la prueba de DNA y no puede tener ningún clase de contacto con la víctima.
The state has consolidated count one. Mr. Gonzalez, you have 30 days to file a notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you. You need to step over and speak to the probation officer.
And if we can use Madam Interpreter briefly to get his telephone number and address for probation.
All right, if you just go ahead and put your phone number and address on the record.
Van a necesitar su número de teléfono y su dirección, por favor.
Ma'am, I'm gonna go ahead and excuse you. Mr. Ferrer is gonna help us.
Thank you, JP. Thank you, Madam Interpreter.
Spirit of Mr. Sims. They'd help him.
And that concludes my business, Your Honor, if I can step over with my
Yes, ma'am.
client.
Have a good weekend.
Thank you so
All right, let's rotate back to Judge Stevens, new contestant approaching there.
25 CR 329, the state of Texas versus Charles Darrell Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. You okay there, buddy?
Yeah.
All right. Earlier, you pleaded guilty to this indictment, which alleges the second-degree felony of burglary of a habitation. A pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, state?
None from the state, Your Honor. None from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So we've got no less than 2, nor more than 10 years confinement. He could be placed on deferred or unadjudicated probation for up to 10 years. And he could also be placed on regular probation. I could sentence you to no less than 2, nor more than 10 years in prison, and then suspend that and place you on regular probation. But you've been on probation before, and that was revoked back in 2002. Then it looks like in 2009, you were sentenced to 6 months in the state jail for drug conviction. So that's 2 felonies convictions. And then we have a marijuana possession, which was regular probation. That's a conviction, illegal possession of marijuana, and that was in 98. And then 03, 30 days in jail. These are misdemeanors. Possession of drugs, 30 days of marijuana. Another in 2012. There were 2 of those in different. That's odd. Look at that. That's the same exact number. That can't be right. They duplicated that. So it's true. That's got to be an error. Looks like you have 3 prior misdemeanor convictions of marijuana.
Yes, sir.
And then 2 prior state jail felony convictions. And all of these are the same thing. It's controlled substances.
Yes, sir.
All right. Go ahead.
Your Honor,
You may go forward.
Thank you.
If you wish.
yes, please, Your Honor. We're gonna ask the court to put him on probation, and we're gonna let the court decide whether regular or straight is the court term of probation. Looking back at his criminal history, as you see,
His time, the credit, please. Thank you. Go ahead.
and like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out on the PSI, Your Honor, is in the statement of interested parties that the victim of the case, who I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation. So if the court was to give probation to this individual, this defendant, the victim is already on board with that, is okay with that. Also, the last sentence there, she said she asked the court to order the defendant not to have any contact with her in any way. If you were placing him on probation, you could make that an order and keep him away from her for up to, and I'm sure the court would do this, 10 years. Versus if you send him to prison, we all know that he's not going to do a full 10 years, and then the court would have no control over keeping him away from his part at that point. I mean, she can go down and get a protective order or something like that, but it's out of this court's hands. But if we were to give him probation, then the court could order him to stay away from her and make it a condition, and that if he violates it, then he goes to prison for up to 10 years of his regular probation. And if the court defers it, up to 20 years. That would give the court a bigger hammer if the court wanted to do a deferred probation. You could sentence him to a longer time if he did violate probation. Also, I think they indicated some drug treatment. I think we can get him evaluated to see if drugs are still an issue. Like I said, I know there's a history of drugs, but the last one, like I said, was not, the conviction was in 2012. So I think that probation is probably the best in a case like this. That's all I have to stop.
And then the other side. Let me ask you, before we go forward here.
Yes.
I was thinking about some things, but everybody has reviewed the pre-sentence report.
Yes, sir.
There aren't any objections here. No. Okay.
Yeah. I know.
All right. All right. Go ahead, State.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning. And he just starts beating her, ends up choking her out several times where she passes out, and she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this, and he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind. I can call him as a witness about
Okay.
that.
Okay. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct? Okay. You did go in the house uninvited, correct?
We went into the house. Hold on. Hold on. Hold on. Hold on. It's all about what the facts are. I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above day, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry, he forced his way is a violent act. Okay, let's correct the record. You weren't invited in. This says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't, what I'm getting at, I was going to question him, is that he was there, they went in, it wasn't a situation.
He's saying the police are wrong in this report.
Well, the
is that what he
police
said? Well, let's come on.
Well,
let's get straight. Is this, nobody objected to this. That's what makes me unsettled. I've got to make my decision on the facts. No one objected to this. This is here. He forced his way in. Is this wrong or not?
That's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His position is different.
That's well,
it's not, we can't object to what the police say.
If there's a big difference between what is being said here by the authority that wrote this and you, point it out to me. I mean, I do read this, but sometimes these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
Well, we had a trial, and the defendant or the victim even testified to that. Okay, but his position is that, and I'm trying to give a question, is that he did go in uninvited, kind of forced way through, but it wasn't a situation where he broke a window or broke a door or went in that type of way.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay, but Your Honor, sometimes with non-lawyers, they don't understand the difference between breaking into and going out without consent. I think
facts are the facts.
The facts are
that's all I want. It's facts.
Facts are facts. But I think when you ask, did you break in? He's going to say no, because most non-attorneys deal with this don't consider just going in without permission.
I've done this for 40 years. I know what you're saying.
Okay, all right. That's what I'm getting at. So I think that explains his version of it, that he didn't break into. I think that's going into it. Now, whether he went in with permission or not, I don't think he went in with permission. I don't think anybody believes that.
But what we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Right. Well, I think the facts are, like I said, the facts are the facts. He went in without permission and some bad things happened. I think there's no question about that. Okay. The question is in his report, I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him, when asking the defendant if he broke into the victim's house, the defendant said no. Okay. So I think that's the issue here, is I don't believe he broke into, meaning broke in a door, broke in a window, something like that. But he did enter. If they would ask, did you enter without permission? That'd have been a different question. Okay. So I just want to make sure the court that's correct. Okay. And it's not an objection to it, because that's exactly what all was said. We're not objecting to any of that, because that's true. But I think the court needs an explanation of that's the difference there.
And it goes, upon entering the residence, this state, he began assaulting her and dragging her through the house by her hair, using his hands to strike her and threw her body about the room. Then used his hand at the front of her throat, grabbed her trachea, then squeezed her throat, cutting off her breathing and causing her to pass out. Does that look like
was invited and welcomed in there, or he snuck in behind her and immediately began to assault her? That's not forcibly entering.
When, Your Honor, there was testimony from the victim that he actually, he was in no way invited. In fact, he showed up behind her as she was going in through her garage and ran up on her.
Do you agree
and
with that?
Went into the house.
Yes.
Okay.
But I'm just saying that the phrase broke into, I think that I don't want.
We're semantics now. Well, I'm talking about he committed the crime of burglary and she was assaulted.
That's why I was.
So let's move on to what the points are. We're bogged down on how he entered the building, but it was for no good purpose.
It was not with permission. It was not for a good purpose, right? But it wasn't a situation where he broke into. I think so. I don't want the court to say that he lied here, because I think his version is that he didn't break into because he doesn't understand what the law says. Okay.
Wait, did he enter her home without her permission?
Absolutely.
Okay, so he trespassed. Okay, that's a crime.
I know. We're not saying that he
To
didn't.
get in, he committed a crime.
We didn't say that he didn't commit a crime.
Let's move forward.
Okay, all right. But like I said, I like to go back to the point where even the victim in this case indicated that probation would be good for him, or she would have no objection to it. And I still think that probation with a restriction to keep him away from her and all the conditions of probation to making sure he lives right would be good. I know he has violated probation in the past. However, in the past, it was a drug-related issue, and it's been quite a while since his last probation. So I think this is the type of case that this would keep him under the court's authority, keep him under the court's eye through the probation department. That this would be helpful for this both the victim and the defendant in this case.
So,
Your Honor, the victim here could have died multiple times. He passed out several times. And by the grace of God, she didn't end up dying and was able to escape. And who knows if she wasn't able to escape, and one of the times when she has to go to the kitchen, what would have happened in the end. So sometimes we have to protect the victims also. In these type of relationships, we know they tend to want to be lenient on the defendants. However, that's a dangerous situation, and what he did was extremely dangerous and horrible. And with those kids, again, dropping them back off over there, and they have to see the house being completely busted up, knowing their mother has been strangled and beat. I believe, again, every bit of that 10 years is warranted in this case.
what would you like to say, sir? This is your time.
Before we turn Middleton to the thing that happened.
What happened? Because he's saying something different than he is.
I went into the house without permission.
And then what?
Yeah, no price.
Then what? Oh, she punched you first?
No, sir. I grabbed her phone and she grabbed me and we started wrestling over the phone, basically. I had no intent to try to kill her or harm her or do anything.
Well, it says you dragged her through the house, used your hand to squeeze her throat, cut off her breathing, causing her to pass out. When she would regain consciousness, you would continue your assault and squeeze her again. This assault went on for several hours before she was able to escape her house, running to a nearby business where a citizen was able to contact the police for her. She sustained injuries in the form of abrasions, scrapes, cuts, and bruises all over her body. Are you kidding me? You're going to stand by what you just told me, that really nothing, you didn't intend to do anything, this was no big deal, in spite of what this says? You don't understand and appreciate the seriousness of what happened in this person's home where she's supposed to live in peace?
Yes, sir.
Okay. Here's another statement that I don't understand that you made to the probation office. When asked how you're going to do if granted probation, you stated, "I'm going to do good. I'm not really a drug guy." Really? What are you? How many convictions do you have of drugs?
3.
Wrong. Do I know more about you than you do? No, in 98, you were convicted. 1 year adjudicated probation of illegal possession of marijuana. In 2003, 30 days in jail. In 2012, 30 days in jail, marijuana. In 30 days in jail. In 2002, let's talk about the felonies now. 2 years state jail, probated for 5 years for drugs. That's 5. That was revoked and you received 6 months state jail. And then in 2009, 6 months in the state jail. 2 felonies and 1, 2, 3, 4 misdemeanor drug convictions. But you're not a drug guy. You don't have an answer to that.
No,
because it's just nonsensical.
I'll speak of recently.
Oh, recently, you mean since you've been in jail? You don't use marijuana in
The
jail?
last 12 years, I haven't been.
Let me ask you this. This event, was this caused by drugs?
No, sir.
So this is the way you act when you're sober?
No, sir.
Yes, it is. Oh. Okay. Within this. Dead. If not, I'm going to find the defendant has pleaded guilty voluntarily. He is mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilt, your plea of guilty from State's Exhibit 1 admitted to your hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. And I am following this agreement. The agreement is whatever sentence shall not exceed a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Okay, you can leave. You can leave.
You step outside, ma'am.
Step outside. This is what we call justice. Your rich criminal history. You have a rich criminal history. You're held in contempt of court.
Keep walking.
Get her. She'll be, you can't make an outburst in court.
Get it. Hey,
You're going to be given credit for all time you have served, but you can't invade somebody's home and assault them. And with your rich criminal history, we knew better. All right. Okay, anything else to add? No, that is all. You can't make an outburst in this court.
I'm
You
sorry.
can be held in contempt of court up to 6 months now. Are you related to somebody here?
I'm sorry, sir. I apologize.
Or that's okay. Are you related to somebody? Who do you know? This man?
Yes.
How do you know him? He's your brother. All right. You were here and you heard what this was all about, right? Did you hear? Okay. It's a very serious thing.
Yes,
And his criminal history was, but here's an issue when he gets out, the family needs to help with this. It's still a drug issue that he's struggling with. And he says he doesn't have a drug problem, but I think a lot of this is based upon what is out there. People don't know what's out there, and what the people are manufacturing cause folks who take it to do odd things, and it's very serious. Some people are dying out there right now for some of this. But I think you're a rational thinker when you're not inebriated with drugs. And I just wish that seems to be your problem. But then you tell me I don't have a drug problem, but you've got all these convictions for drugs. But it's one of these things that the family's going to have to help you. John, I want you to talk to me about what you might be able to figure out what plan you might be able to do to put him into a facility, which this court might consider doing before this term is completed. You know what I mean?
Yeah.
Because he needs that.
Okay.
And the family seems to be supportive of him, but you've got to be firm that his actions can't be tolerated. And it's Christmas time. It's supposed to be where the family gets together and enjoys life, and they're not with you. You're not with them. And but there's a way to avoid that. Okay. Thank you. Let her go.
So we don't often see people acting out from the onlookers here at TCF. Quite honestly, I think we act out more than the people who are actually in the courtroom. But, you never know what you're going to see here. That's why you join us every day, because you just never know. Oh, new contestant. I was going to switch up, but let's just stay here.
What do we have? Your Honor, this is an announcement. I think this is just a situation where it's just money. I don't believe there are Mr.
I have this thing in abeyance.
Yes.
Give him a time. It has to be for restitution, I guess, right? Or
There's no restitution, it's just fees.
Yes, sir.
And
Okay.
he's
There's a
paying, but it's
motion to
correct.
revoke pending that alleges money, all about money. And you had a bunch of $7,700 in arrearages as of December last year. So where are we on all that?
He made a payment in September of 25 for $100, and he just made a payment in December of $302, but the payments haven't been
Irregular.
consistent at all.
So that's been 400 in a year.
Right.
So
And
we're talking about, 35.
Right.
And this case expired on January 19th of this year, Judge.
Except we extended it.
Except
No,
it's not-
the motion's held.
it's just-
Right now, the motion's
holding.
Yeah, the motion's holding it.
Yeah, I understand.
Yeah.
And I've talked to him about this, and he apparently had lost his job. It's not working. He just started a new job. He's
Where?
I work for an electric company.
Doing what?
I'll go in the attics and drop the wires through the wall.
Full-time job?
Yes, sir.
How much you getting paid an hour?
They pay me by the day. They go anywhere from $100 to $200 a day.
Okay, so, but how often in a month would you say you work?
In a
We're trying to
month.
get a standardization here.
How much will I bring in a month?
Well, no, how much are they paying you a month? I know you got to pay taxes and other things.
I just started this job about 2-3 weeks ago.
Okay, so you really don't have
No, I don't have a full month.
long-term figuring out of a steady, but it's regular?
Yes, every day.
Well, good for you.
And apparently since he's been working, he's made a payment recently because he's been getting some payment now.
Yeah, my first check just made it through.
Is everything else frozen?
Yes, sir.
Okay, so it's not accruing any more costs. It's just a matter of paying the balance. What's probation saying?
I mean, if it was more regular, I wouldn't, there wouldn't be an issue.
How long have you had this job?
2 weeks.
See,
Right.
maybe
Cross your fingers.
it will turn into a regular income.
Yes, sir.
But he sounds like he's positive about it and hopeful that it is.
So we'll go back in a couple months and see if he's been making payments.
That's what I'm going to do. We'll check on you in a couple of months. Okay, work hard and stay out of trouble. Thank you. John, is it, is that it?
I got one more, Amanda. It was Amanda Nolan. I don't think she's going to be here, Your Honor, but it's one of the status checks, see if she's checking in and doing what she's supposed to do, but I don't think she has everything that she's supposed to do.
Who is it?
Amanda Nolan?
Okay. Amanda Michelle Nolan, cause number 1932306 is called. Amanda Nolan. There is no answer in the courtroom. I ask the bailiff to call into the hall, please, for Amanda Nolan. And the court will note a first amended motion to revoke probation has been filed in this case. She is on a regular probation, failing to report, I guess, and then first amended, failing to report. Is she in abscondence now?
No, just this month, she hadn't really returned any calls or reported in. Yeah, anyway, twice, she didn't show up.
Okay.
There's no response, John.
There's no response. Defendant has failed to appear. A warrant shall be issued for her arrest. She's on regular probation. What I'm going to do is, there is no bond on this. When she gets arrested, we'll know and we'll bring her forth. But she's on regular probation, so no bond is allowed under these circumstances. All right, John. Thank you.
It's all. You have a very Merry Christmas, Your Honor.
All right,
See you after
Santa. Remember our address? Okay.
Both of them. Y'all later.
Okay, I've got Reagan on Ezekiel Johnson.
He's a plea judge. She's in custody.
Okay, Ezekiel Johnson, please.
Here, Judge, you accidentally gave me the file earlier.
Did I?
You did.
What does that say?
That.
I'm trying to move my cases.
What? You need to call your desk.
Biden. Okay, I hadn't seen these. I've got a gaggle of letters on his behalf that's been sent. I just opened the file. There it is. I didn't know these were here. Stamps are all. You're Ezekiel Johnson? Okay. Is Catherine Edmond here? Okay, I have a letter on your behalf, but it's not signed. You just, that's okay, but you did send a letter.
That's my job. We didn't know they had to be individual.
Okay, well, generally letters are signed, otherwise people can just print them off and, use other people's names and all. But you did want this.
Yeah.
You approved this.
Yeah, I'm not Catherine, that's.
It says you. It says Catherine Edmond RN.
Yeah, that's my daughter. She's not here today. I wrote a letter too, I'm saying.
Oh, okay.
Catherine's my daughter.
Okay, but Catherine didn't sign. Are you Hannah? Are you Hannah?
Right.
Okay, I've got Hannah Byers as well, and that as well.
None of them are individual, I didn't know they.
Okay, how'd y'all send them? Just fax them or something?
Okay.
Okay, but everybody, let me look at this other one. Then I've got something from Robin Byers. Okay, and then Tabitha Armstrong. Okay. Lee Byers the second. Lindsay Byers, and there's not even a signature line here, but that was meant to be sent to me.
Oh.
Okay, and then from Parker Johnson and Anisha Belton
It's all family.
and Rupert Johnson.
That's pretty much the grandfather.
Okay, all of those are, I just want to make sure because they're not signed, but they're all valid.
Yes, sir.
Okay.
All
I
right.
hadn't looked at these. I don't have these.
Ask the number, so.
I wasn't aware, Judge, they were sent directly to you. They did not come through my office.
Let me go, there's something else I'll get back to you on this one. So
We haven't agreed upon resolution, so I'm not.
but it's a motion to revoke unadjudicated probation, so I don't have to do that. It's gonna be whatever I decide.
Sure, Judge. I have 3 others that we could do first.
What did you?
2 years DDC, Your Honor. He's got new cases out of Nacogdoches.
Is there any loss of restitution? Is there restitution or anything?
Usually they punish you, but
You have a pre-sentence report on this for the. They also found the weapon at public close when he was put up for that.
yeah, I think I've done it.
Dan, I must say, the tie and handkerchief match the suit perfectly.
Oh, thank you. Much place my eyes. I have yes.
This really nice outfit there. strange for the DA's office, they can coordinate. They generally have flashy, they wear flashy clothes, and that's a theory, You get the jury's attention, you're wearing flashy clothes. It's a strategy. Yeah. And they trade off each clothes, they trade off clothes, they're wearing each other's clothes. That's so you can confuse who they are. Okay, you had been shot in this event?
I did myself on accident.
He accidentally shot himself, Judge.
It says several gunshot wounds to your left leg.
Yeah.
You shot yourself more than once?
It went through my knee and it hit me in the foot. That's
Okay.
I think it was just one.
It says lying on the ground with several gunshot wounds to his left leg.
yeah.
Oh. And yeah, but it's always a good idea to go to get some training on firearms use before you go out and shoot yourself.
Yes, sir. It's hurt. Yes, I've heard nerves.
Okay, so he's got unlawfully carrying a weapon at a prohibited place in 23. That was this then, right? Yeah. Okay. That's looks like the only criminal history.
That's great.
Okay. Here, thank you. All right, does the we call 22-39919 Ezekiel Emmanuel Johnson. There is a first amended motion to revoke unadjudicated probation. Mr. Johnson is here with Ms. McNally, her attorney, and the state's attorney. Does the defendant waive a formal reading of this first amended motion to revoke probation? Can we proceed in sign?
Yes, Judge.
And sir, please raise your right hand, Ezekiel. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this states that on April 6th, 2023, you, in this court, you were placed on 5 years deferred or unadjudicated probation for the third-degree felony of unlawfully carrying a weapon in a prohibited place. Is that true?
Yes, sir.
You know, it's a place that sold more than 50% of its supply of goods in alcohol-related items. First amended, can we do number 7, bail jumping?
Sure, Judge.
Okay. Allegation 7 states you committed the offense of bail jumping on or about March 5th, 2024 in Jefferson County, Texas.
No, Judge.
In Nacogdoches County, Texas, which is in violation of condition 1 of your deferred or unadjudicated probation order. Is that true or untrue?
Yes, sir. It's true.
And then finally, number 8 states you failed to report to the Jefferson County Probation Office for the months of December 23, January, February, March, April 24, etc. Was he an absconder for a long? How long?
About 2 years.
Hello. Where you been?
I was homeless and didn't have a job at the time. So
My court probation department was June 8th, 2023.
You have to report. I mean, if you can't do anything else, you got to report it. You are not on really supervision. You're on your own supervision, which is not the way it was. You have to report. That's really the easiest thing to do, but that's what gets you in trouble because that's really the most important thing. It's all about supervision. All right. Are you pleading true to allegation 8, failing to report to the probation office as this states in violation of condition 4 of your deferred adjudicated probation order. Is that true and correct?
Yes, sir.
So are you pleading true and correct to allegations 7 and 8 voluntarily, knowingly, intelligently, and because those allegations are true in this first amended motion to revoke unadjudicated probation filed on July 25th of 2024?
Yes, sir.
Do you understand that one or more violations of probation proven by a preponderance of the evidence or greater is enough to grant a motion to revoke probation like this one? Your probation can be revoked. You can now be found guilty and sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily to allegations 7 and 8 of this first amended motion to revoke unadjudicated probation. You understand and appreciate the consequences of pleading true.
Yes, sir.
Okay, what are we doing on it?
2 years TDC.
Do we have an agreement?
Yes, Your Honor.
I don't have a pen. An agreement's been reached here where your probation would be revoked. You would be found guilty beyond a reasonable doubt of this underlying offense of unlawfully carrying a weapon in a prohibited place, a 3rd-degree felony, sentenced to 2 years in prison. Is that your understanding of the agreement?
Yes, sir.
And then we've got all of these numbers here, plea of true to number 2, which is not what we did.
No, we can change that to 7, Judge.
Okay. Let's just. Takes 5 seconds after you put something on it for it to show up on the pen. We're getting these changed soon, they say.
The new ones are here, Judge, so you just have to program them. So maybe it'll be under the Christmas tree. And this is why.
Heard that. I've heard that since I was a young kid. I've learned there's some tomfoolery going on.
On a nice.
Okay, so allegations 7 and 8 of the MTR motion to revoke probation first amended. You had pleaded true. To allegations 7 and 8 voluntarily, knowingly, intelligently. I find that supports the first amended motion to revoke unadjudicated probation in this case, to grant it by preponderance of the evidence or greater, and your deferred or unadjudicated probation is hereby revoked for this third that he found. Earlier in this case, you had pleaded guilty to this indictment voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here that finds you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of that underlying the crime of unlawfully carrying a weapon on a prohibited place, a 3rd-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. I'm showing you what's marked as State's Exhibit 1. Did you sign all of that? Understand it? Discuss it with your attorney? Is everything true and correct? State's Exhibit 1 is tendered into evidence without objection. Among other things, this states that you are waiving all rights of appeal. If I follow this agreement, I've done that, and you have no right of appeal. You will be given credit for all time you have served in accordance with this case. Do you understand what's happened today, sir?
Yes, sir.
Anything else?
No.
That is all. Thank you, Wallace.
All right, so in just a minute, we're going to go ahead and go to Dungeon Court to finish out the day. However, something just showed up in my feed. And, you know, we do breaking news from time to time. So I'm going to show you guys this. As you can see from the Chiron right now, bridge go boom. So this is in Lansing, Iowa. This is the bridge between Iowa and Wisconsin. It's called the Black Hawk Bridge, and they just did a controlled demolition of it. So let's watch it go boom real quick. Boom. Although it seems like on the left side there, some of it might not have collapsed the way they were hoping. I could be wrong. Maybe it's what they wanted. Yeah, bridge go boom. Just thought I'd share something a little different on a Friday here. You never know what you're going to see on TCF. Ashley says satisfying. I'm glad you found it satisfying. All right, my friends, let's, the capper is not in. It is a substitute judge. However, they are moving through the souls of those in custody that are still living, which is a rare sight to see the in custody living in Dungeon Court. But let's go there. If you're new, Dungeon Court is a guilty pleasure of ours. Horrible production value, horrible sound. You can hear the sounds of all those who have been sentenced and have since died. The crimson red carpet. It's crazy. It's Dungeon Court.
All right, there's a State of Ohio versus Lawrence Calderon, CRA 23-522 A and B. We'll start with that one. All right, Mr. Calderon, it's alleged that on or about April 6, 2023, in Fayette Township, you did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance, in violation of Section 292511 AC 1A of the Ohio Revised Code. Possession of drugs, that's a felony in the 5th degree. Felonies of the 5th degree carry up to 1 year of incarceration and a $2,500 fine. In the CRA 23-522B, it's alleged on or about April 6, 2023, in Fayette Township, that you did knowingly obtain, possess, or use a controlled substance or controlled substance analog. Said drug involved is a fentanyl-related compound or a compound mixture, preparation, or substance containing a fentanyl-related compound, or is a combination of a fentanyl-related compound and any other controlled substance in less than the bulk amount, in violation of Section 292511 AC 11A of the Ohio Revised Code. Possession of a fentanyl-related compound, that's a felony of the 5th degree, carries a maximum of up to 1 year incarceration and also a $2,500 fine. Do you have money to hire an attorney? Are you working currently? All right, I'll find you qualify for appointed counsel. I'll appoint Attorney Stratton to represent you. I'm going to, Mr. Hill's matter of bond. We also have a bench warrant issued on a failure to appear from March 18th of 2019. And then it looks like it was reset at some point. It looks like Mr. Calderon may have shown up, and it was set as an arraignment on August 11th of 2023 for the failure to appear, and then he did not appear for that either, it appears. And all of them several old cases. And those are reviews.
Your Honor, we'll ask for a signature on all these matters. They are felonies.
Mr. Hill?
Your Honor, taking into consideration the failure to appear on the prior cases and the fact that these cases have been out there since April, don't really know the circumstances that caused it to take so long for it to come before the court, but we would ask that for one of two things, either a $5,000 cash or surety bond, or if Mr. Calderon was interested in talking to somebody about treatment, we would ask the court then to allow him an OR bond if he were to go to treatment, if he needs to go to treatment, and if it's recommended by a counselor. So, Your Honor, the failure to appear was apparently involved in frustration to Washington. So he was available for court.
So when was he released from incarceration in West Virginia?
April of this year.
Okay.
So, Your Honor, I think that it'd be okay to get an assessment done and then follow the recommendation of that assessment.
All right, here's what I'm gonna do. Just up until we have that assessment done, I'm gonna set bond at $5,000 cash as surety. Does somebody like to assess Mr. Calderon? All right. Yeah, I saw Jessie back there raise her hand. She's gonna come back and do an assessment on you, and then we will recall the matter after the assessment and then discuss the bond and where it goes from there. Matter will be recalled later in the docket.
State of Ohio recalls County Burnside, case number CRE 25338.
Mr. Stratton, you may want to keep these two together with their reviews on the same case. All right, we're recalling the State of Ohio versus Connie Burnside, CRA 25-358, Mr. Stratton's case.
Your Honor, I have to speak with the prosecutor. I understand the state's willing to reduce the charge of criminal mischief. We guilty to that charge, let's take the facts, situation of guilt, and I understand the state will recommend just suspend the time.
Could I have a section on that, please?
Look it up. $2909.07.
And Mr. Burnside, is it your intention to enter a no contest plea that stipulate to a guilty finding to the misdemeanor? Okay. Is that a first degree misdemeanor?
Third degree misdemeanor.
Okay, it's an injury.
Your Honor, for the record, if I may, this started out as a disrupting public services, but the facts were that, as alleged, that Mr. Burnside took the young lady's phone out of her hand and threw it. There was no accompanying domestic violence charge, which usually those things go hand in hand. There wasn't in this case. They were just, I guess, they were bickering at each other or something. And we have not gotten any information about damage to the phone, so we're not going to ask for restitution.
Okay. All right, I'll accept your no contest plea and enter a guilty finding. It's going to be a $100 fine. I'll order you to pay your court costs. How many days has he been incarcerated?
Same way as diagnosed with Crohn's disease, not being in here for this, I mean, no excuses definitely about this way, but just ready to get this taken care of.
What days has he been out?
Your Honor, he was booked on the 18th.
Okay. All right, so I'll do 10 days jail. I'll suspend 9 and give you credit for the day that you've been in. So it'll be released today. It'll be 2 years level 4 probation. And Mr. Field, are you looking for a protection order?
No, Your Honor.
All right. And no contact order is not requested at this time. I'll set you a review hearing for July 13th at 9 a.m. Thank you.
Justin Horn, case number CRA 25203. And this is Mr. Morgan's case.
All right, this is case number CRA 25203, State of Ohio versus Justin Horn. Mr. Horn is present. It's Mr. Morgan's case. It's set as a preliminary hearing.
Tyler? Tyler?
They can waive to the grand jury, or you can have a preliminary hearing. What's it say now? 15,000? 15,000.
It's listed on the charge as 290311, 18, felonious assault.
So there's quite a bit of restitution. Your contact order, and here's the thing with the restitution. There might be some things that you can't, of course, and pictures and estimates and everything here. This is the damage to the car. This is his, yours. Not the missing early. If he's not dead, no crime victims pay his estimate. And the phone was destroyed. It's not the cover for this incident. Now, there's one more thing, and I told him, no, it's wrong. I think this is civil. That when he left the scene, he sped off because I was like, I got a ticket. He sped a ticket. And I said, he's already paid our victim for this incident. He's paid for the ticket, but then if he can compensate for the ticket. And of course, this is for mileage for Canada.
$400 for a speeding ticket.
Yeah, he's got paperwork on it here.
In this court?
Was it here that you got the speed ticket? Chesapeake, Mayor's Court.
Okay.
But I told him I didn't know about this stuff probably, but if we could come back and he's got the payment.
Okay.
And we're not able to just work it here.
Your Honor, we may have a way to work this out today, and I don't know whether the court has time for us to do it right this minute or not, but I think we can make an offer that Mr. Horn might be interested in. This is a serious charge.
I read the narrative. If to be believed, it's very serious.
Yes, and so I can go ahead and just kind of outline it. What it would involve is a plea to a misdemeanor level assault, and this is Mr. Chapman here, and this is your idea, right? There's restitution that is this in addition?
The court will do this.
Okay, well, if they'll agree to it, I'm
I
sure.
mean, but.
All right, so the restitution is going to be around $2,160. And that would include several different things, which we've set, I've got this here for them to look at. And it involves damage to the vehicle, it involves medical bills and some other things. The restitution would have to be would have to be made in short order. And we would also want a suspended jail sentence of 6 months and probation and credit for time served and suspend the rest of it. But we would want to delay the sentencing, let Mr. Horn out of jail. He'd have to come up with the restitution in a very short matter of time. So we would then agree to the rest of the provisions of the agreement. A no contact order. And it'd be really important for the restitution to be made up front. Otherwise, we would ask to be able to not stay with the agreement for suspended jail. In other words, we would want him to spend some time in jail. What we really want is for this to get resolved in such a way that we don't have to take it to the grand jury. I'm just kind of thinking out loud at this point. I guess I'd like to know from through his lawyer whether he thinks he could come up with the approximately $2,160 restitution in short order.
Now, if I'll go ahead and tell you my thoughts on it. If I'm even going to agree to it, I would want to set a time frame that it has to happen within.
Yes.
And so that, this case isn't, 8 months down the line, we're still trying to come up with restitution.
Matter of fact, I think maybe the best way to handle it would be to give Mr. Horn a bond before there's any plea to anything, and then have him come back with the restitution. Then we would agree to amend it to a misdemeanor, and upon his plea, then we would agree to the remainder of the
We're going to be at least 2 months. Restitution.
Well, I don't know. Is that more time than you want to give him? And Mr. Chapman says that's okay. And I just hope Mr. Horn knows that he's been pretty daggone generous under the circumstances to say that 2 months would be okay. Because I don't think I think that's too long. But we would agree to do that if the court would.
Okay. So here's what we're going to do then. What bond would you like me to set, Mr. Gill? What bond would you like me to set in this matter?
Well, it would be, I think, an OR bond, and it should be substantial enough to give it some weight. There's also a protection order in place.
All right. Mr. Horn, I'm going to amend your bond to a $5,000 OR bond. I'm going to keep the protection order in place, that's presently in place, which means you can have no contact with Mr. Chapman. You will have I'm going to set you back, and Mr. Morford, I presume you're fine with wait time.
Yeah.
I'm going to set you back for February 20th for a preliminary hearing. I'm going to note the time waiver on your client's behalf. Mr. Horn, you better have your restitution at that time. Because I can tell you if the allegations in this are to be believed, you're lucky that you weren't charged with other more serious things as well. And that's not to say that if it goes on to the common police court as a felony, that the grand jury won't indict you on other things as well. So I will reluctantly go along with this at this time, but they're giving you 2 months to get the restitution together. If you don't get the restitution together, they're likely going to take it over as a felony at that point. Do you understand? I see you nodding your head, but we're recording. I want to hear you say it on that line.
And the restitution amount exactly is $2,158.85. That's payable to Tyler Chapman. Oh, you didn't have that in?
Well, no, is that 80 cents or
$30.80.
Why not? I need all the couple cents. 17.28 plus 400 plus $30.80. That's actually my calculator sometimes. Okay. Plus 400 plus 30.80. That's what it's actually.
All right. Actually, we were wrong by a couple pennies. It's $2,159.65.
All right, Mr. Horn, so you're going to be able to sign your bond and get out today. So we'll see you back on February 20th at 10 a.m. And it would behoove you, even if you can't come up with a restitution, to appear for that hearing, because if you show up and they decide to take it on, then you could potentially waive that preliminary hearing and possibly keep your bond. If you don't show up and they acknowledge the case to the grand jury, you'll get a brand new bond when you get to common police court, and it will not likely be as generous. All right. See you back on February 20th. Thank you. Thank you.
All right, my friends, that is it for today. Programming note, the next 2 weeks obviously will be a little bit different with court because there's some days where they'll have stuff going on and some days where they won't. But there will be programming in this time slot every day for you, whether it be a live show or whether it be a best of or something. Something will be broadcast, so be sure to check in, stop by, chat with each other, all that kind of stuff, because we're not going to take the time off. Thank you to everybody for everything that you did today. Thank you for joining, for liking, for subscribing, for your super chats, for your gifted memberships, for all of that. Very much appreciated. I will likely be back in the chair on Monday. I'm pretty sure there will be enough court to do the live, so hope to see you all then. Have yourselves a great weekend. Take care of each other. Enjoy yourselves. And until next time, take care. God bless.